Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Thank you very much once more again. I would like to sincerely welcome our PS, Chris Kipto, our board members, Chair, most welcome, and all our distinguished guests in the room. You are most welcome for this important session for us. Since the authority started 15 years ago, this is our first inaugural lecture, session, for conference. And I would like to state that in the past, we used to have capacity building sessions for stakeholders. And this year we thought, given that we are 15 years old, we need to graduate to harvesting ideas on competition and consumer issues in the region. And we thought it wise to have this conference. And as a result, we have gathered here practitioners, policymakers, and competition experts from the region and also within Kenya. From the region, we have participants from South Africa, just to mention a few, Zimbabwe, Zambia, and UK. And we do have sessions as panel presenters, moderators in this forum. And all these are competition experts, and they have pre-written papers which are going to be presented in plenary sessions and breakout sessions. And what we intend to do is to harvest evidence-based policy recommendation and practices across the region. And with those few remarks, at this point, I would like to invite our Director General to welcome and give his remarks. David Kimei, karibu sana.
Thank you very much, Dr. Adano. I'm very grateful this morning and actually delighted to have all of us here to attend this inaugural research conference by the Competition Authority of Kenya. Without much ado, we are going to start because our guest of honor also is pressed for time, so we want to make it pretty short so that we can get going. So allow me to welcome our chairman, Mr. Charles Mainda, to give us his remarks. Welcome, Chair. Clap for him as he steps forward to give his remarks. Welcome, Chair.
Thank you, DG. Thank you, delegates. I will make some very short remarks and then invite the DG, portfolio management from the Treasury to come and invite the PS. Good morning. Good morning. I hope I'm audible enough. I'm truly privileged to welcome this distinguished gathering of policymakers, researchers, enforcement experts, and partners, all united by a common passion. That is the pursuit of fair competition, robust consumer protection, and inclusive markets. So on behalf of the Board of Directors of CAK and the management, I wish to express our sincere appreciation to our keynote speaker, Dr. Chris Kipto, CBS, Principal Secretary, National Treasury, for honoring this invitation. Bona PS, your presence underscores government's unwavering commitment to evidence-based economic governance, and thank you for making time to be here. I also wish to acknowledge Mr. Lawrence Kibet. I don't know whether he has turned up as yet, right? The Director General of Public Investments and Portfolio Management for gracing this occasion. To my fellow board members present, Mr. David Kimei, the DG CAK, heads of agencies present, and all other members, I wish to welcome you to this conference. Karibuni sana. Let me say we are gathered here today at a pivotal moment, not only when the Competition Authority of Kenya, but also for the Kenya and regional economies. The theme of this year's conference of promoting competition and consumer welfare in a globalized and dynamic market is not merely a title, but a call to action. As you have seen from our program, the next 2 days are structured around two critical pillars. One is the competition policy, development and implementation, which includes how competition aligns with the national goals such as SME growth, industrial policy, and climate change. This is captured in the first plenary session. The second structured critical pillar is competition and consumer protection in digital markets. Here, the conference shall be exploring digital financial services, algorithmic dominance, data privacy, and cross-border challenges. These shall be covered under the second plenary and breakout session. I'm sure, as you're all aware, the authority is currently implementing its fourth strategic plan that covers the period from 2023 to 2027. Now, this plan represents our two main commitments. One is to strengthen our enforcement tools and legal framework so as to keep pace with emerging markets and global best practices. The second commitment is to promote transparency, predictability, accountability in delivering our core mandate. Dear participants, these commitments align perfectly well with our conference theme. As the authority, we are planning, going forward, in adopting a new policy, a new philosophy, where we are actually moving from soft to hard enforcement. And this is necessary for us to maintain the integrity of the authority. Over the last several years, the authority has moved from soft enforcement to hard enforcement. This is now the clarion call and the philosophy of the board going forward, and particularly for repeat offenders. Ladies and gentlemen, you notice that over the last couple of years, the authority has successfully extinguished four cartels that oppress consumers, suppress economic growth, and foreclose opportunities for various SMEs. Though at the same time, we've witnessed an increase in contraventions to the competition law, but we have kept pace with it. With the unending support of the National Treasury, the authority recently invested in a forensic lab that should enhance our analysis on evidence-based and data analysis. This will enable us to draw more comprehensive and indisputable inferences as far as enforcement work is concerned. Similarly, the authority has also reviewed the Competition Act, and this has been done 4 times. Each of the review was necessary as we expanded our enforcement frontiers. The most recent review, which has been undertaken, is currently lying before the National Assembly. And this should enable us to regulate the dynamic digital markets. And I wish to seek on the policymakers present here to advocate for the fast tracking of the amendment bill. PS, I'm sure if you engage your colleagues, you can actually get to unlock this amendment bill that is lying in Parliament. As we all know, one of the drivers of economic growth are the SMEs. The government has identified SMEs as a critical driver of economic growth through job creation, enhanced product development, and efficient value chains. Now, towards this end, the authority has intentionally prioritized this by enforcing abuse of buyer power, provisions in the law, and facilitating recovery of about 3.5 billion Kenya shillings in delayed payments that has been owed to the SMEs. The second priority has been on reviewing our merger thresholds. You will notice that any transaction with an asset value of 500 million and below does not require the authority's approval. This certainly gives the SMEs a head start by lowering compliance and transactional costs. Ladies and gentlemen, what is our true North Star? Our true North Star is our ability to collaborate and partner with some of the members from the academia. We have also become active members of the global competition community, contributing to the practice and development of competition regimes worldwide. If you allow me just to mention a few. Firstly, our leadership in developing the AFCTA competition policy is well documented. I am also reliably informed that one of the sessions during this conference will be dedicated to the role of regional cooperation, with research papers being submitted to deepen our knowledge on this subject. I have served at the Ministry of Trade and Industry for a pretty long time, about 30 years, and I can personally attest to the power of regional integration in enhancing trade. The authority was among the inaugural members of the African Competition Forum, which has handheld newer African agencies in establishing and implementing their own competition laws. Secondly, the authority has also secured leadership roles in the international competition networks and international consumer protection networks. These memberships have enabled us to adopt global best practices, access tested work products from other jurisdictions, and interact with practitioners who have passed on these invaluable skills to our staff. After all, as Eleanor Roosevelt reminded us, we should learn from the mistakes of others, and we can't live long enough to make them all. I could go on and on, but you can see how proud I am to lead this incredible organization. Its most valuable asset being skilled human capital, while leveraging on partnership as our top priority. Ladies and gentlemen, we must acknowledge the indispensable role of research and appreciate that we cannot take the risk of making arbitrary decisions that are not supported by research data and incontestable evidence. It is for this fundamental reason that the authority, to deliver solid and defensible decisions, the authority has prioritized partnerships with the institutions of higher learning to support it in policy research and market inquiries. I am now sure you can see why this conference matters. The papers you will present here on market power in East Africa, algorithm dominance, cross-border agricultural trade, and many others will not be mere academic exercises. They are the bedrock of our enforcement and regulatory framework. As we engage with the distinguished panelists, speakers, and paper presenters, I can only state that this conference comes at a time when new knowledge and new ways of doing things are required to tackle emerging global challenges. I therefore invite all of you to actively participate in this deliberation over the next 2 days. Remember what Henry Ford once said: anyone who stops learning is old, whether at 20 or 80. Anyone who keeps learning stays young. The greatest thing in life is to keep your mind young. We must therefore endeavor to stay young, all of us. Let us use this conference to keep our minds young. Let us actively participate, and let us all learn new ideas. Now, with those few remarks, Mr. Lawrence around? He's okay. Okay, with these few remarks, it's my singular pleasure to invite our chief guest and keynote speaker, Dr. Chris Kipto, PS, National Treasury. Welcome, PS.
Yeah, Charles Mahinda, the chairman of the CAK, board members present. You can see my former colleague at Ministry of Trade, Josiah Rotich, and my alternate from National Treasury, JZ Ngugi. And all participants, good morning. I'm Jambo. I'm sure even those from other countries now know at least there's one word called Jambo. Jambo. Hamjambo. So let me take this chance first to apologize for coming late. We are at a moment we are getting ready to present our budget to Parliament. And so we are very busy at National Treasury. I was in the office by 7 a.m. and trying to organize things here and there. And then I had another meeting also like this that I was presiding. But I believe I'm not too late. So accept my apologies. Thanks CAK for inviting me once again. I remember the last invitation was in December when I came to preside over the launch of the OECD peer review report. And today also I see you have a very good conference, research conference on competition and consumer welfare. I've done research before. In my earlier days, I used to attend a lot of conferences. I miss them. I wish you had organized this such that I could have had time to come and listen to the papers, go through them. Because otherwise we begin to rust as people who are also experts in this area. But allow me now to dwell on my speech, and then I will have to rush back to the office. So let me say once again, I'm honored to join you today at this conference. I commend the CAK for organizing this seminal event that has brought together policymakers, researchers, people from the academia, and other stakeholders so that we deliberate on this important subject matter of consumer competition and consumer protection in this globalized and very dynamic marketplace. It's a conference that comes at a time when we are in the fourth medium-term plan of implementing our vision, which is ending in 2030. And at the moment, we are placed as a country, I think we were number 8 as in Africa. We'll be number 6. I hear there's a report that has just been released. I need to see where we are. But I just want to say Kenya is implementing a transformation agenda that puts most vulnerable citizens, not just at the connected, not just the most connected ones, at the center of growth. However, our economic development aspirations are not self-executing. They depend entirely on whether our markets are fair and inclusive. So let me ground this in 2 sectors that can tell our story well. And I start with the agriculture sector, which contributes about 22.5% of our GDP and contributes indirectly about 27% GDP through manufacturing, distribution, and services. It also employs about 40% of our workforce, and more than 70% of our rural economies are dwelling in agriculture sector. Therefore, when anti-competitive conduct distorts the seed market, for example, it raises input costs, squeezes farmers out of their fair prices, and harm more than just one sector. Such conduct destabilizes the livelihoods of millions of people. It is for this reason that effective competition enforcement stands out as a critical food security and poverty reduction instrument. The same logic also applies to the small and micro enterprises, the SMEs, which the chairman alluded to. This is a sector that accounts for about 34% of our GDP and employs approximately 50 million people. We have a workforce of about 21 million currently. And in the formal sector, private sector employs about 2.3 million people. The public sector employs only 1 million. So the rest are in this category of MSMEs. We call them hustlers. They are hustling every now and then. Unfortunately, 1 in every 5 of these fledgling farms fail in their first year. Only a third survive to their 10th birthday. Why? These failures are not the result of lack of talent. It's not because of lack of innovation or drive on the part of those entrepreneurs. But it's mainly because the level playing field is not even. In many instances, big market players delay their payments, impose unfair contractual terms that transfer risks downwards, or foreclose the distribution chain by creating barriers to entry and expansion. Further, price fixing contraventions render certain services inaccessible to and unaffordable for SMEs. Regulatory regimes such as unfavorable licensing policies further increase transactional costs and affect supply chains. So the Competition Authority of Kenya exists precisely to dismantle some of these arrangements. Through review of proposed regulations and laws, as well as through the market studies and inquiries, CAK's advice to government of Kenya is important, especially to ensure lowering of barriers to and ensure that our small businesses have a fighting chance to thrive. From where I sit, competition is not just a regulatory concept. It is an economic policy instrument that directly shapes investment decisions, employment outcomes, the cost of living, and the sustainability of our public finances. When markets work fairly, the government's job becomes easier. Where they do not, we pay for it through lost economic growth. Edward Deming, an American data scientist, aptly reminds us that without data, you are just another person with an opinion. The Breaching Barriers study, jointly released by the World Bank Group and the CAK in December 2025, gives us the necessary data and insights to move beyond opinion. This study determined that Kenya's product market regulation index stands at 2.92 out of 6. This means that our regulatory environment remains significantly restrictive to competition, with 209 state-owned enterprises operating in sectors where private sector competition should be thriving. Addressing trade and investment barriers could raise formal employment by 2.6% and real GDP by 4.9% by 2035. This is what the report said. These are opportunities that competition enforcement must take up in order to support our economic growth and inclusivity agenda. In the same breath, the recently published peer review on Kenya's competition enforcement framework undertaken by the OECD provides an evidence-based diagnosis of the challenges and opportunities we face. The review offered incisive recommendations on how to strengthen the CAK's tools, procedures, and processes. And I'm aware that the CAK is interrogating these external reviews to domesticate and action proposed solutions that will further unlock economic activity through competitive markets. One area where the response is particularly urgent is public procurement. Government procurement accounts for roughly about 60% of the national budget. I think some of you are familiar. The budget we have presented to Parliament now is about 4.8 trillion shillings. I don't know in dollars. Of that 4.8 trillion, you net out 1.5, which is for what we call CFS. It goes for debt and pension. So the balance of 3.3 is what is available for both national government and county governments. County governments about 500. The balance of 2.8 is to now national government. And that is, I would say, probably would form part of procurable items, of course, minus salaries. But just to say that every shilling lost through bid rigging is a shilling stolen from a school, a road, or a hospital. So I allowed CAK's structured partnership with the Public Procurement Regulatory Authority. Elimination of bid rigging schemes is among the most fiscally consequential areas that needs our urgent attention and intervention. And I think this is one area we have been doing a lot to improve our public financial management, all the way from accounting, finance, procurement, up to audit. And so we see you also, that partnership with this, PPRA, key. Taxpayers deserve value for money. And I implore both agencies to step up their collaboration and address persistent issues that antagonize our markets, more so by disenfranchising our small and medium-sized enterprises. Ladies and gentlemen, let me be direct about the role of National Treasury and the continued commitment to our competitive markets. We will continue to resource CAK at a level commensurate with its expanding mandate, including it into emerging frontiers such as digital markets. Since 2011, the government of Kenya has invested over 8 billion shillings in this institution in recognition that it has a role. Its role cannot be relegated to the back of the line. Whereas resources are finite and competing demands are there, we shall continue offering our support to ensure that this driver of growth is enabled to play its role adequately. Secondly, we are currently supporting CAK in the development of a competition and consumer welfare policy, which seeks to anchor competition enforcement and consumer protection within the broader economic transformation agenda. In Kenya's case, the Competition Act preceded the policy. So we intend to now buttress competition principles across government, not just within one agency, and aligns our framework with our obligations at the national, regional, and continental level. When the draft document is submitted for public participation, I want to encourage all of you to provide your candid feedback and input, especially the people in this room. You are rightly placed to give us your enriching insights. Lastly, most of you are aware, I think, Chairman, you alluded to it, we have the Competition Amendment Bill that is now before Parliament, and our intention is to produce a revised law that supports the authority in responding to emerging issues, more so in the digital economy. As has been stated by earlier speakers, issues such as algorithm collusion need to be anchored better in the Competition Act to facilitate better enforcement, which is in line with global best practice. The National Treasury has fully supported the process so far and will continue to doing so until and after we have a revised Competition Act that aligns with present-day enforcement realities. So, ladies and gentlemen, the value of this conference does not lie in the paper shared alone, but in what happens next. Research must close the gap between evidence and policy. The ideas you present in this room over the next 2 days should, as appropriate, find their way into enforcement decisions, legislative reforms, and government regulations. That is the standard I would ask you to hold in this conference. Competition markets create jobs, enhance inclusivity, and consumer welfare. They also reduce the cost of living and build an economy that works for everyone. So let us make the most of this moment. With those many remarks, it's my honor and pleasure to now declare the Research Conference on Competition and Consumer Welfare officially opened. Thank you very much, and I look forward. I wish I had the chance to stay with you longer, but I ran the risk of ensuring that I don't have something for my minister to present to Parliament next week. So allow me to go back to the office quickly. Asanteni.
Pana PS, stay a bit so that we take a photo with the directors, and then we will now allow you to leave. Welcome.
professional association agreements as provided for under sections 28 and 29 of the Competition Act, respectively. If as a business you believe that particular collaborations or agreements will result in great
For sure, you guys look lovely from here. And allow me to just say once again, welcome to today's program. I'm going to be taking you through the day. So allow me to invite Professor Simon Roberts. But just before he comes onto the stage, balancing competition with broader public policy goals. So this session is going to focus on how competition policy aligns with other national policies and contributing to socio-economic goals. This includes sustainability and climate change, public interest considerations, industrial policy, SME participation, and inclusive growth. So allow me to invite Professor Simon Roberts, and even as he comes on stage, let's put our hands together for him as we welcome him to the stage. Karibu sana. Okay, Professor Simon Roberts is an expert economist who straddles the field of competition economics and industrial development. In his role as a professor at University of Joburg with the Center for Competition, Regulation, and Economic Development, he leads major research projects on competition, innovation, and inclusion. Professor Simon has worked extensively on issues of competition, industrial development, trade, regional and global value chains, and economic regulation in South and Eastern Africa, advising governments, competition authorities, and regulators. He has established the Center for Competition, Regulation, and Economic Development at the University of Johannesburg and has led it to become the leading research institute on competition economics in Africa. Professor Simon has further published extensively on competition and industrial development issues in academic journals and has edited 6 books along with a number of journal special issues. Again, I'd like to also invite our panelists for this first session. Allow me to invite Mr. Albert Mwenda. Okay. Allow me to invite Ms. Doris Shepe. I believe she's joining us online. Then also allow me to invite Mr. Nderitu Mwangi. We can put our hands together as he comes on stage. Allow me also to invite Mr. David Kemei. Allow me to confirm if Ms. Doris Shepe has joined us online. Ms. Doris Shepe, please confirm if you've been able to join us online.
I hope you can hear me.
Yes. Yes. Thank you very much. Ms. Doris Shepe is Commissioner, South Africa Competition Commission. And Mr. Nderitu Mwangi is a former Chief Executive Officer, Competition Tribunal, and the board member at the Communication Authority of Kenya. And of course, we've already been introduced to Mr. David Kemei, the Director General at CAK. So welcome, and over to you, Simon.
Thank you very much. It's a great honor to be here this morning to chair this session. And thank you very much for the kind introduction. It was very unfair because the idea of the coordinator is to make all the panel members look good. And I got all sorts of comments about my publications. And actually, we were a very esteemed panel here today with extensive experience in competition matters, two leaders of competition authorities, a former chair of the tribunal, now a CEO rather of the tribunal, and on the board of the Communications Authority. So we're very fortunate to have such a wonderful panel here. And I think we're going to pick up on a lot of the issues that the PS raised in his speech. It was kind of music to my ears as a competition practitioner. Also, we're moving from soft to hard enforcement. So I was like, okay, this is putting the panel on the spot. DG, you've come right into the hot seat here, I think, now. We structured the panel to around 3 major stages. So we're talking about competition and broader public policy goals. This is a huge topic. This is about how the whole economy works. So we structured it in 3 stages. First of all, taking the big picture of economic development. Unfortunately, DG Mwenda, who was going to talk to that first, is not here, so we'll go to the DG of CAK. We'll then look at issues of participation and inclusion, because clearly we don't just care about how much the economy is growing, we care about where the money is going to. People need to feel it in their pockets. So we really need to understand how markets are working in terms of questions of participation and inclusion. And then, because of the diverse experiences of the panel members, in the 3rd round, we want to dive in, take some deep dives into particular questions. And so I'll pose particular questions on topics to the panel members in the 3rd round. And then I hope we are going to have time to invite questions from the floor. So this is your chance to pose some of questions on these topics to the panel members. So I'm not sure, I haven't been instructed as to whether we still have the full time, but I'm going to try and negotiate from the chair with the organizers, so we'll see how we get on in terms of time. All right, so this is very much meant to be interactive and engaging. So I'm going to turn to DG Kemei, first of all, to kick us off. So the strategic plan, which has been shared with us, sets out a series of objectives. And I want to ask you, how does the plan align to government priorities with concrete examples? We heard about bid rigging and housing, which was one of the issues I actually wanted to come to because of the steel cartel that the CAK uncovered. But I also want to know, how are you going to measure tangible impact? Because we can produce reports, inquiries, but people want to see impact. So please tell us, answer those 2 questions if you can, locating the work in the context of the broader government policy goals. We only have 1 mic. Do we not have more? Okay, let me pass the mic.
Can we have a second mic, please? Thank you so much, Professor Simon, for the questions you posed to me. I think I will answer them in that order. The first is about the strategic plan, which in essence, all of us know that the strategic plan takes into account where you have come from and where you're going to, and then it takes into account the priorities of which you need to undertake in terms of strategic initiatives and the resources that you require to reach where you're going. For us in Kenya, we have the ministry or the State Department for Planning. It's come out with a guideline on what can be done in terms of strategic planning by government entities, including regulatory agencies like CAK. And therefore, what we do as CAK is first and foremost to align ourselves with the key government policies. And we actually project that in line with our mandate, which is actually, first of all, to ensure that we promote efficient markets. So what kind of initiatives are we going to take in a planning span to ensure that we actually execute our mandate in line with the government priorities of the day? We are cognizant of the fact that as an authority, we don't operate in a vacuum or in isolation. And again, markets also don't operate in isolations as well. So what we do is we make sure that in our mandate, we actually align our key priorities with key policy goals of the government. For instance, if we are talking about the impact of costs of agricultural inputs and the rest, and the value chain, that's now where we align our plan with the priorities of the government in agricultural sector and value chain to ensure that we are fostering competition in that sector. That goes with bid rigging, as we mentioned, even the PS has mentioned. We say in 5 years, what initiatives are we going to undertake to ensure that we deal with bid rigging as it were. And so many other issues to do with cross-border transactions. Again, we do this in line with the priorities of the government of the day. I want to say also that if there is a change of administration ministry, again, we prioritize according to the priorities of the new administration, ensuring that we still retain our goals that we must achieve within the span of the strategic plan. Thank you very much as far as that is concerned. I want to add also that in one of our departments, which is the firepower department, it zeroes in mostly on how to promote small enterprises. And you find most of the administrations in Kenya have key policies that promote SMEs. Again, we plan and prioritize as well on how in competition space we can work with government to ensure that huge enterprises do not abuse their strategic positions in disadvantage of the small scale enterprises. You had asked me to give specific examples. Those are some of them. Thank you very much.
Thank you very much, DG Kamai. I want to move to the other head of an authority that we have on the panel, Commissioner Doris Tepe, who's online, to ask about the experience of the Competition Commission of South Africa in setting priorities in light of the government's development agenda, and how the Commission in South Africa consults on that prioritization process. So I'm hoping that, Doris, we heard you earlier, so you were loud and clear, so it seemed everything was working there. So over to you.
Good morning, to everyone. Thank you, Professor Roberts. I hope you can hear me loud and clear.
Yes, we can hear you loud and clear. We're not getting a picture, but the voice is, oh, maybe we are, it's coming now. But go ahead anyway.
Yes, can you hear me? Can you see?
Not yet, but we can hear you. Yeah.
Very sorry about that. So first, Professor Roberts, thank you for the opportunity. And let me first congratulate Mr. David Quebec and the team from the Competition Authority of Kenya on the inaugural research conference on competition and consumer welfare. Thank you for inviting me to participate on this important topic together with the esteemed panel. I'm very sad that I could not join you in person, but I'm glad that I can still participate virtually. Professor Rose, before I discuss the issues of prioritization, I just wish to speak a little bit about how South Africa has dealt with issues of developmental agenda and competition policy. As most of you are aware, South Africa has included developmental agenda, what we refer to in South Africa as public interest provision in our act from inception. First, we included public interest provisions on measure control and exemptions, and more recently with the 2019 amendments, we have included public interest provision and abuse of dominance and market empowerment provisions. However, the success in dealing with these issues is in large part about careful identification of what public interests to pursue, how each one finds application within different areas of competition law, the legal standard applied, and the careful development of jurisprudence to develop an analytical framework and legal certainty to business, because we believe when you want these things to be clear to everyone, it needs to be in the law, it needs to be clarified, and you need to have an analytical framework to be able to assess it. So as new areas of potential public interest emerge, as countries seek to embrace public interest objectives, it might be important to reflect briefly on some of these aspects. First, which public interest issues to pursue, and I think here, and South Africa and other African authorities would know country context and history obviously matters, and so does how strongly the issues may tie to the structure of the economy and the exercise of competition. For instance, a focus, which is, I'll deal with that in the next round, a focus on participation of SMEs in what we call historically disadvantaged persons had a peculiar resonance in South Africa due to historical exclusion and highly concentrated structure of our markets. It is also more closely tied, we believe, to competition law, as it finds expression in the economic structure, and ultimately is about exclusion from markets, which is a core element of competition law. Second, where does public interest likely find application within the Act? Our Competition Act has been selective in where public interest finds application, and we have adopted, as you know, a gradual approach where deliberately we found at the very beginning, as I said, we had public interest provisions in measure control and in exemptions and data in abuse of dominance provision and market empowerment. What this has done is to allow us to develop a jurisprudence along the way, and then are able to add new ones. As I already mentioned, participation of SMEs in HDP has found broad application across all aspects of competition law in South Africa due to its link to market exclusion and the reason it was identified as the only area for abuse of dominance in the last amendments. In contrast to employment, we see that employment features more strongly emerge funding complaints leniency application to achieve the stated priorities of the government within the mandate of the Competition Commission. The prioritization framework will guide prioritization even at an operational level as we consider the extent of impact. For example, high impact in non-priority areas or low impact in priority areas and impact on local consumers. So what are the sort of themes? The themes we're focusing on are intervention to remove high impact legislative and regulatory barriers in prioritized focus areas, initiation of intervention to support change in market structure in prioritized areas to reduce concentration and promote competition and dynamism of those markets. Initiation of intervention to remove barriers to entry and participation of SMEs and firms owned by historically disadvantaged person in prioritized sectors, resulting in new entry, improved participation to support growth through industrialization. So these are some of the areas where we think we have been able to do so. We have also conceptualized areas, sectors, what we call sectors, as well over and above themes. For example, we've looked at our sectors that we have prioritized in this strategic cycle is agriculture, food processing, retail value chain, which I think, as we all know, these areas that are of concern for all of us, including here on the continent. The healthcare value chain, digital markets, industrial sectors in the main. So these have been some of the areas that we've been working at. How do we have, as you've asked Simon, consulted on this? I mean, we have heard formal consultation in the process of strategic setting of priorities, but we also use informal engagement with various stakeholders. At formal level, we engage with government, both at the Minister of Trade, Industry and Competition, and other departments where our work will impact on them, but also with the legislature. And we do engage with business, with labor, and civil society. We have also, through market inquiries, market studies, and even the advocacy work that we do, given the data that we collect, try and get all of this. And this is how, in the main, we try to consult and get the work going. I think I'll end here, and if there are any further areas, I can cover them later if you like. Thanks, Simon.
Thank you very much. Thanks, Doris. That was very comprehensive, very useful. I think we've got, and I just want to congratulate CAK, we've got digital platforms and agriculture on the agenda, so we're actually going to be going into these in more detail. Let me bring in Mr. Mwangi Nderitu now, former CEO of the Competition Tribunal, and we're going to draw on this experience first of all, and then as board member of the Communications Authority, a follow-up question. But from your position in the tribunal, you've had a great vantage point to see the casework and the issues that are coming through. And I mean, it's difficult when you've been part of the system to be critical, but I'm going to push you a little bit to say, if you're looking at the past 15 years and with a view to learning for the next period, how successful has competition enforcement been in addressing exclusionary abuses by dominant firms? Because one of the objectives is to tackle where dominant firms are blocking small businesses, and this requires enforcement. Now, it's obviously a process, so I want to ask you to reflect on that. Thank you.
Thank you so much, Professor Simon. I also want to take this opportunity to congratulate the CAK, DG, and the board members for this research conference, which give us an opportunity to review how we are doing as a country or as nationals from various jurisdictions. And before I answer the question that Professor has asked me, I wanted to give you a few highlights in terms of the Kenya's industrial policy that explain Kenya's industrial journey from 2012 to 2030, and our view and our aim as a country in terms of the industrialization policy is to ensure that our manufacturing sector is contributing about 15% of the Kenya's GDP. And a part of the government approach, number one, for those, for example, who belong to Kenya, we have come up with what we call the county aggregation parks, where the 47 counties of this country are supposed to look at small areas where they can start small manufacturing industries, whether it is garages, motor vehicle, and all that. They are being set all over the country. And then we also have what we call the special economic zones. The government has been very aggressive in the special economic zones within various counties to enhance the industrial bit of our country and to ensure that we leverage on other sectors. And then number three, we also have what we are calling the sector-specific value chain under the national industrialization policy as a country. And this again is supposed to address the small areas or the small raw materials that we have in our counties. And specifically the bottom-up agenda, we had discussed what we call the textile industry. We were to look at the cotton industry, and then see how we revive the textiles, and also we had to look at the leather from animals and all that. Then we had agro-processing for the foods processing, which we were supposed again to, Kenya being an agriculture country, we were supposed to look into that. And then the other component was the development of SMEs, and then the final one is what we call the Buy Kenya and the Build Kenya initiative, where we were actually saying that we need to encourage our local people also to continue buying the local products, especially those that are being manufactured by the local farms. Regarding my experience at the Competition Tribunal, remember under the Competition Act, the law mandates the tribunal to confirm or to review or to look into the decisions of the Competition Authority of Kenya. So at the tribunal level, therefore, which is basically a court, more like a court, there wasn't a lot of analysis that we were doing at the tribunal level, but our key issues was in the aspect of looking at the available evidence that was presented or that is presented before the tribunal from the Competition Authority of Kenya. And the mergers and acquisition that have been filed before the tribunal, I want to recall that under the Competition Act, mergers and acquisition, we have a public interest component where the Competition Authority can assess the extent of how a merger can affect employment. And some of those arguments, I used to see them before the tribunal, why the Competition Authority is advocating a certain merger. Those are some of the few issues that you look into, because under the Competition Act, the Competition Authority can consider a merger on public interest by looking at simple aspects like, is it going to lead to protection of employment, or is it going to improve in employment creation in terms of the future strategic plan of that merger? And the other bit that you also used to check, and I used to see, I've seen this come before the tribunal, is the ability of the mergers, how they help small farms gain access to competitive markets, which again, you're going to see huge farms entering into agreements with the small farms and maybe in agriculture processing. And then they are supposed to start exporting to AU or to any other country, or EAC, or any other part of Africa. So, and then there is also the issue of access to international markets. Again, another public interest under the Competition Act, which I have also seen the Competition Authority advancing before the tribunal, and maybe before we consider a merger. And then there is the other bit, technical efficiency, research and development, efficient distribution of goods and provision of services, and access to markets. So at the public interest, therefore, I can say that before the tribunal, I have seen those particular components being advanced by the authority, but I have never seen a contested decision where the authority has absolutely used public interest, and maybe the parties are contesting the authority decision. But as I have summarized there, I have seen all that. Currently, again, where I am at the Communication Authority of Kenya, we have huge initiative to support industrialization as a government, because one of the major vision of Communication Authority of Kenya is digital access to all and the most disadvantaged parts of this country. So at the Competition Authority of Kenya, where, Communication Authority of Kenya, where we have huge firms like Safaricom and we have others, what we are doing is that we are ensuring accessible and affordable ICT services, even to the most disadvantaged counties. So we have extended fiber infrastructure, for example, to Turkana, very far areas outside Nairobi. And the idea is to bring interconnectivity to undeserved and remote areas, ensuring access for all citizens, regardless of their location or economic status. And we have moved further as Communication Authority by promoting digital literacy and skills training within the various stakeholders. And we have what we call accessible and affordable services, where we are going to have mobile network connectivity project, expanding voice and data network in remote sub-locations, which we are calling Phase 2 and Phase 3, targeting all marginalized areas of this country. The idea is to ensure that we support the government industrial policy in the various disadvantaged areas. But under the Competition Act or Communication Act, remember we also have the competition aspect, where we are supposed to monitor licenses to ensure that there is infrastructure sharing between the large telecoms and also the emerging telecoms that are joining the new markets. At the same time, we are also considering the aspect of consumer protection. When you are using your mobile phone, for example, a part of the analysis is to ensure that the phones and the SIM cards we are using are not exposed to radioactivity, rays, or some certain chemicals that are likely to affect you as a user. So therefore, in this industrial policy, as we advance this topic, I think Kenya, the various institutions, we are arriving to it, and we continue monitoring the markets to ensure that cartels, and also that there is fair play in the marketplace, and small enterprises can also grow, but at the same time, we advance the interest of the big corporations.
Thanks. I think we're going to come on to also looking at the competition and communications interface, which you're already now talking about. So I'm looking at the next question thinking, okay, am I going to skip it or am I going to come back to you on that? I'll come to DG Kamai and then Commissioner Sepe, I'll come back to you on the South African experience on Black empowerment afterwards. I think I want to now take on the other hat as a moderator. Sometimes you can play devil's advocate and be a little bit stimulating, because one of the things that the tribunal doesn't seem to have faced, because it didn't come to you, is many cases of exclusionary abuse of dominance. Because you talked about public interest in mergers, and it's not a criticism of the tribunal, because you only see what comes to you. Public interest in mergers, and so I want to turn to DG Kamai and say, in abuse of dominance cases are hard, but if you are not taking them on, you are not taking on cases where you're excluding small businesses. And so the honest answer is there's not been many cases of exclusionary abuse of dominance in the past 15 years in Kenya. This is not unusual around the world. There also have not been many cases. So how are you going to improve the impact in addressing conduct, such as by dominant companies, which excludes SMEs going forwards? And then we'll turn to South Africa. Also, has struggled with this. So I want to put you on the spot and say, okay, I'm being devil's advocate now. It's not been, there's been good in some areas. Buyer power, maybe we'll talk about that. But how are you going to step up to what the PS is also asking for, I think?
Thank you so much, Professor Simon. I want to give a few measures that we think we adopt and we've been adopting will actually help ensure that SMEs are not excluded in actually our markets, because they are very critical, as have been mentioned even by the peers before. The first is that one, we want to collaborate with industry associations so that within these industry associations we ensure that the issues of competitions and the issues to ensure that SMEs are not excluded, we are able to make sure that dominant firms do not exclude SMEs. That's the first one. The second one also is that we would like to enforce abuse of power regulations as well as merger control. As CAK, we are reviewing those abuse of power guidelines to ensure that we take into account what is happening in the markets, and so that when we enforce those regulations, we ensure that small farms are not excluded from by huge businesses. The other one is that we are undertaking proactive advocacy and awareness among the small farms. And every year we take that initiative to different counties and meet the different small scale enterprises, so that we make them aware of their responsibilities, of their rights vis-a-vis dominant farms, so that they are able to exert their rights and in terms of when they are doing businesses. So we design a program like for a week, and we visit different counties and engage with small businesses. I think this year, this financial year, we engaged small businesses in Gishu County, Kakamega County, 3 counties this year, in addition to the previous counties that we have engaged before. We even changed the strategy this year so that we are not only talking about abuse of buyer power by dominant firms, but the entire spectrum of customer consumer welfare, as well as the other antitrust actions that huge farms can actually do to abuse the small farms. So those are some of the activities, some of the measures we are taking. In addition to that, we also find that it is very important to standardize some contracts between huge farms or large farms and small ones, so that the large companies do not take advantage or impose their dominance by actually having some exclusive provisions in contracts that benefits the huge companies to the disadvantage of small companies. So we've stepped in there, and I think we are promoting issues to do with the codes within the different industries, so that then codes of practice within the different industries, so that we have a level playing field between the large companies as the small companies in the different sectors. Thank you, Professor Simon, for asking me that question.
Thanks, Eugene. I think the codes that you finished off with there is one of the big successes, I think, that other countries can really learn from. It's something that we've been encouraging South Africa to actually learn from. So it's a good point to turn to Doris again. Doris, but I mean, I want to come to you and say, I mean, in South Africa, of course, the legacy of apartheid means that exclusion has got a very particular role in terms of tackling it in terms of redress and changing the structure of power in the economy. I want you just to reflect on that from the competition authority perspective, and explain what you think are the lessons that can be learned from the successes, but also the failures. Because I think, we like to talk about our successes, of course, we're all human beings, but, learning often comes more from what has not gone so well. And I think this is obviously an ongoing challenge that South Africa is grappling with, and I think it does have much wider resonance in the context of the legacy, the colonial legacy in countries across the continent. So if you can do that, we are running short of time, and it's such an important topic that it's difficult to manage it, but I'm just wanting to highlight that, if you can, give us your insights. Are we able to get the audio on from the link again?
Can you hear me?
Yes, we're good. And we can see you as well, by the way. So halfway through the previous intervention, we got your picture.
Oh, you did. I'm glad to hear that. So just to go back, the purpose of the Act and the mandate of the Competition Act of the Commission is to promote an inclusive, competitive economy. What this does is it recognizes that we have inherited a highly concentrated economy that excluded the majority of the population. This creates both a competition concern, but also an exclusion concern. So when you are addressing exclusion, you're not only dealing with equity objectives, but you're also addressing competition by removing barriers to entry of businesses that can contribute to growth, employment, and a more competitive economy. And it is in this context that the Competition Commission has dealt with part of its mandate on transformation. So the transformation in support of SMEs has been given the label of public interest. But in reality, what this is promoting inclusivity and bringing the talents and energies of previously excluded entrepreneurs into the economy and aiding their expansion, which then improves competition and achieves growth. Our discussion has relevance not just to competition, but also to industrialization. Sector, which accounts for less than 25% of economic value, compared to half of this in other OECD countries. So yes, promotion of greater strength of ownership, as we have it in our Act, by historically disadvantaged persons and workers is indeed a core objective of the Commission. And it is for this that we have dealt with this, and we have had some 2 decades of experience. And collaboration are not given practical expression in the operative provisions that decision makers must apply. And you know this because you can have institutions struggling to give effect to the broader purpose of the legislation. Courts may interpret the law narrowly, and stakeholders may become uncertain about what the institution is actually mandated to achieve. And we've seen this in some cases, and you know that one of them is the nation-wide polls judgment, for example, running governments. So what we have always said is have these as clear as possible in the Act. And so the amendments in 2018 sought to deal with these gaps between the objectives of the Act and tools available to enforcement. We did that by having a clear provision to support participation of SMEs, the legal standard applicable at the time, which would have made it difficult in the nationwide polls matter, was amended, and now we have provision expressly recognizes harm to SMEs and firms owned or controlled by historically disadvantaged persons. And the law therefore provides a more direct mechanism to address exclusion, conduct targeted at vulnerable market participants. In measure control, while promotion of religious private ownership was in the purpose of the Act, it wasn't in the actual provisions of Section 12, and that has since been included, including greater participation by SMEs and firms owned by historically disadvantaged persons. And so you needed to have that very clear. So these are some of the examples of why you would want to have that clear. It's clear to set up in your law. The second lesson was about stakeholder acceptance. And this was acceptance both internally in the country, but also globally. As you know, South Africa for the longest of time was the only one with these provisions, but gradually you've seen other African authorities, but also more broadly in other areas where you have specifically objectives being put in place. But I think here, one of the lessons we learned was guidelines on how we intend to do this and engage with various stakeholders to take them along on this journey was a key area. A third lesson is that empowerment cannot be pursued only through transaction-specific interventions. Measured control can play an important role in achieving empowerment outcomes. However, lasting transformation requires attention to the underlying market structures that determine who can participate in the economy. This recognition has increasingly shaped the Commission enforcement and advocacy agenda. With market inquiries, abuse of dominance enforcement, supply development initiatives, and advocacy intervention, we have sought to identify structural barriers that prevent SMEs and HDPs from entering, expanding, and competing more effectively. Those are the three lessons we want to talk to. I know you, time is not on your side, but I just thought I should raise those. And if there's anything else you want me to, I could. I was going to deal with our program on the removal of regulatory barriers, but I understand that we may not have enough time. But I thought I should end there. Thank you, Simon.
Thanks very much. I think this program of removing regulatory barriers that is on the South African Commission's agenda coming forward is something I'd really like to touch on. I'm going to ask the organizers if we're going to have time to come back to it once we've done the last round of questions. So let's put that on hold. I wanted to have specific issues I want to pick up with the panelists now. And to Mr. Nderitu, coming back to this issue that you are touching on, when you've got, under digitalization, we see digital platforms which are bringing together capabilities which cut across telecommunications, they cut across competition issues, they cut across finance. Now, Kenya is the example in the world of the company that has done this, right? So we all talk about Google, but of course, if we're talking about Kenya, we're talking about Safaricom. This generates enormous benefits just like Google does, you know? Lots of efficiencies, but at the same time, it's a giant. It comes with the territory. It's not a criticism. And, you know, companies are there to serve their shareholders as well as their customers. So I want to say, in the context of addressing financial inclusion in digital platforms, how have and how should the communication and competition authorities really work together in Kenya? And also, it's very confusing because you're both CA or CAK. So this is just an outsider's comment. So maybe you just merge together and we just have one CAK. No, that's a joke. I'll get into trouble for that later. The question is, how can you work together? Thanks.
Yes, thank you, Prof. Under the Communication Act, one of the sections requires Communication Authority of Kenya to work in collaboration with the Competition Authority of Kenya. I've not been in CAK for a long time. I'm not sure whether they have been collaborating. I'm yet to know. But there is a lot we can work together between CAK and CA, Communication Authority of Kenya. One, in the areas of digital platforms. We know that financial inclusion, especially in PESA and all these digital markets, e-commerce, in areas of artificial intelligence, in areas of product safety, which cut across the ICT sector, and the Competition Authority is mandated to look into that. But also under the Communication Act, the Act gives the regulator explicit mandate also to investigate cases brought before us under the ICT sector. So maybe we may figure out a lot of collaboration together because my view is that the Competition Authority of Kenya has a lot of knowledge as well. We need to cross hands with the Communication Authority so that we are able to deepen our investigations and in the ICT sector. Digital markets, it's highly complicated, and I feel is an area as a country or even as nations, we may not be very, in terms of capacity, I think it's an area that requires a lot of scrutiny. When I look at the CA, we have a cybersecurity directorate, and they study on a daily basis the cyber attacks that come facing our country and our various enterprises. The cyber attacks in terms of our exposure, it's in terms of billions of activities done to try and hijack the data systems, the online platform that are doing advertisements. And this is a huge area that require strong government investments. Something that is also interesting when I was looking at the EU has come up with a strong framework how to leverage on their ICT sector and how also to make their strong ICT companies stronger. Because when we talk about Google is America. So it will do business throughout the world. So if you have Safaricom, for example, of Kenya, I think I would support Safaricom for it to leverage the markets outside Kenya. Because we are always saying that dominance is not the issue. The abuse is the problem. So to me, I think we should not see big firms as a threat, because world over, countries are supporting their own countries, their own firms to do exports and to leverage on the international markets and to access those markets. So is an area that is very gray, but I wish that we continue exploring together. And even in future meetings, we hope that we continue involving CA, Communication Authority of Kenya, in these meetings, so that we can deepen some of these things. Because I have seen in our strategic plan as CA, we are supposed to do a sector study on competitiveness in the ICT markets. That work can also be done by the Communication of Kenya. So I mean Communication Authority of Kenya. So we'll be looking of how do we deepen that survey so that we reduce the cost of licenses, the cost of opening cyber farms, and the cost of opening telecoms in this country and broadcasting television stations, radio stations, and teleposts, so that we see how we improve this particular sector. So I believe, Prof, there is a lot of working together that we need to work together moving forward, and I agree that we can do this.
Thanks very much. Turning now to DJ Kamai. The OECD peer review was referred to both in the opening and also by the PS. It was a very robust evaluation of Kenya's competition regime, and Kenya went along and said, we want to be reviewed, we want to get better. And the OECD was very focused in terms of their comments, and they said a number of things. One was that there needs to be much more robust enforcement of areas such as cartels. So while 4 cartels have been identified, as mentioned, and they're very important big cartels, the question is that just the tip of the iceberg, number one? And number 2 would be, well, have those firms paid penalties which will deter them from colluding again? So I want to ask you whether you agree with the diagnosis of the OECD, and if so, what steps are you taking going forward to make the enforcement more robust?
Thank you, Simon. On the question of OECD peer review, I want to say that Kenya, or CAK in this case, was actually taking a very bold step to have the peer review. We had one peer review before, and this was the second in the life of CAK. And it is a process, professor, that actually compares how the other agencies are carrying out their mandate vis-a-vis what we do. So we began by looking internally and actually carrying out rigorous self-assessment in which we critically examined our processes, our practices, and institutional realities, complemented by external input from stakeholders. So once we realized that we needed that rigorous assessment, we then came up with a project with terms of reference that then OECD picked on and implemented to come up with a peer review for Kenya. I want to say that it was an engagement from the beginning to the end. So when we talk about the diagnosis by OECD, we are talking about also the participation of CAK in OECD coming up with that diagnosis. So therefore, OECD came up with several recommendations, and you picked one of them. I want to say there were many more, so that this conference doesn't think it was only one aspect. But I think for the interest of today's discussion, you were picked on cartel. We have given an example before of 4 cartels in the lifetime of CAK. We want to say also that it takes a while to really investigate and conclude on cartel issues. So that's one of the aspects that we need to look into. Secondly, cartel by its nature is not a simple exercise. It's a really complex activity by the concerned parties. So we want to say we agree with the diagnosis of OECD because I said we participated from the beginning to the end. And I want to say that already I want to pick three main recommendations to demonstrate that we agree with the diagnosis of OECD. The first one is the issue of improving enforcement. So as CAK, we have engaged National Treasury, and I'm happy our PS was here, to secure adequate human and financial resources. And so far, we have invested about 45 million shillings in coming up with a forensic lab that will help us to investigate and analyze cartel activities and come up with evidence of whether there is really a cartel activity taking place or not. And also come up with evidence that can be sustained before a competent court of law to demonstrate that the parties were actually involved in a cartel. This investment will really improve substantially the way CAK will be dealing with cartels going forward. I will not mention what is happening with cartel activities at the moment. It is too sensitive to mention, but let's say that this investment of 45 million shillings is going to do quite a lot in helping CAK become more effective in handling cartels in our economy. The other one is institutional cooperation, and I'm happy you had asked CA about cooperation, and I think this is something we really want to capitalize on, leverage on, so that we can deal with things like bid rigging that our peers mentioned that it's really taking quite a lot in terms of public funding. Therefore, we will work with PPRA, the Public Procurement Authority, regulatory authority in that sector, to ensure that we deal with bid rigging going forward. Lastly, number 3 is that CAK will improve transparency and also CAK's performance in publishing better reasoned decisions to improve stakeholder understanding of its decision. That's one of the key issues that came up, and we are going forward to really work on it so that our decisions will be better understood, and it will really help further the jurisprudence in terms of competition law. Finally, let me state that the shift from where we are will not happen overnight. It will be a process. Rather, it will be a continuous process that will require a collaboration of multiple stakeholders, including academia, government, legal fraternity, and private sector players, to ensure that CAK implements the recommendations that came out of the peer review. Let me say also that we are zeroing in on those recommendations, and we are moving forward in actually getting stakeholders to work with us in terms of coming up with pragmatic ways of implementing the recommendations of OECD. We are among the few agencies that have dared to go this road of peer review. Thank you very much.
Thank you very much. So I'm now going to ask for guidance because we started very late, but we've already eaten the tea break. So I would like to do a round of questions, but there are great sessions coming up. Okay, I'm getting a shake over the head. So I can then only say that we're going to pick up the issues of digital platforms, of food and agriculture. I'm sure we'll have the issues of bid-rigging coming up in many of the other great sessions that are coming up in the conference. So, and apologies, those who are hoping to hear about the work in South Africa, but you can find it on the South African Commission's website doing a review of the regulatory barriers. It's going to be a very interesting project to watch. So it only belies me now to thank all the panel members, the 3 panel members, for the contributions. I think it's laid a great basis for the issues that the rest of the conference is also going to pick up, and to congratulate the CAK again on their ACD review, but also on the conference structure and issues and organization. So thank you very much, everybody. A round of applause, please. Thank you.
Professor Simon, for that session, and thank you very much to the panelists. We have a group photo of the panelists who are present. So we go back to the session that we skipped. In the previous session, we had a session that was presented by Director Kimei on leveling the ground. So he's going to take us through that session briefly before we go for a cup of tea. Thank you very much. All right, thank you very much. We'll get back to that session later on when we have some time slot. Because of time that we have lost at the beginning of the session, we can go for a cup of tea and then before we could begin the next breakout sessions. So you can proceed for a cup of tea just outside the conference room. Thank you.
Technical team, is Mr. Prosper online? Okay, Mr. Ziaduma, you may proceed. Do you have a presentation? Yes, you can see your screen. Yeah, put it on PowerPoint mode. Then you may proceed to make your presentation. You'll have 10 minutes. Over to you, Prosper. Okay, thank you so much, Prosper. You're within the time allocated. We are going to ask you questions later, so we want to allow everybody to present. So guests, please write down your questions, and you're going to address them once they all present. So I'd like to invite Mr. Samuel Roba. Mr. Samuel Roba is works at the Competition Authority of Kenya in the Buyer Power Department. Roba, welcome.
Thank you very much, committee. And I think I've been introduced, so I'll proceed. I work with the Competition Authority of Kenya, the Buyer Power Department, and we'll discuss more about the issues. All right, as we wait for the presentation to come up. So I work with the Buyer Power Department, Competition Authority of Kenya. And today we'll be discussing the role of ex-ante provisions relevant to, of course, Kenya's competition regime, specifically issues to do with abuse of buyer power. So buyer power, of course, by definition, as provided for under the interpretation section of the Act, speaks to the influence or the power exerted by, of course, a purchasing undertaking on a supply undertaking. And the key issue here is actually the elements to do with bargaining position, to impose unfavorable terms and issues to do with long-term opportunity costs. So with that background, I think we'll proceed to the introduction section of my presentation. And the theories that I've actually relied on in actually putting the paper together speaks to the issues to do with theories of social change. If you look at the evolution of elements or issues to do with buyer power, you'll realize that the first introduction of issues relevant to buyer power was in the 2016 amendments. That was the first time buyer power issues and concerns were actually factored in the Competition Act, now Cap 540. The subsequent amendments were in 2019, which actually introduced proactive enforcement tools that, of course, the authority currently relies on in its enforcement, which again complements the usual enforcement that we do. So having buyer power essentially is not an offense. The abuse of that power is what actually the authority considers as an offense in terms of investigating elements to do with abuse of buyer power. So we have three elements that we look at that in the Act. We have a look at the nature and determination of contract terms, issues to do with pricing between, of course, these particular players, and of course payments requested over and above commercial requirements or what commercial practices permit. So in addition to those three factors, we have other factors that lie in the buyer power guidelines, and they speak to issues to do with dependence, economic dependence, the nature of the market, whether the buyer is a gateway, of course, to that market, and so on and so forth. So today, we will not focus on issues to do with the usual enforcement that we do. We will speak to, of course, the roles that, of course, are these alternative enforcement mechanisms relevant to, of course, which I call ex-ante. They are not ex-post. Of course, they complement the ex-post enforcement mechanism we have, but the ex-ante ones that we will discuss today are not reactionary. They, of course, look into, of course, the conduct or the potential conduct that may happen before, of course, they crystallize, into, of course, conducting abuse of buyer power. And traditionally, I think what competition law has generally focused on was, of course, the process itself, ex post, subsequent to the conduct happening. But in this case, the issues to do with buyer power comes in handy when it comes to our setup And that is why I think in 2019, of course, Parliament decided to factor in these two issues, three issues that I call ex-ante mechanisms that actually the authority utilizes in terms of its enforcement. So the main challenge that we have, and I think in the morning sessions have been discussed, speak to the elements to do with SMEs. And you'll realize that over 90%, some data it actually indicates 80%, still a significant amount or a significant number of businesses in Kenya are actually small and medium enterprises. And actually that indicates the kind of work that, of course, the authority has to do in establishing or ensuring that the market is fair on both sides of the suppliers and, of course, the buyers. And we realize that by dint of these particular suppliers being SMEs, they rely heavily on these particular buyers. And that is where the concept relevant to buyer power, of course, arises. These small player or these supplying undertaking, of course, relying on this particular larger supplier because of their bargaining position in the market, because of issues to do with access to market, and so on and so forth. And the common abuses, I think, that motivated inclusion of these particular provisions in the Act, again, speak to the conducts that we see on our screen. We've witnessed issues to do with delayed payment. We've had undertakings collapse, of course, with supply undertakings, of course, monies relevant to payments of course, the service and, of course, goods that have been supplied to them. And that is where we see a thin line. Do we, of course, enforce post-collapse? I think that will not make sense. But ideally, getting into the market, of course, getting to understand the players in this particular market before, of course, these conducts crystallize, I think will be a preventative or a preventive approach in a way to ensure that the buying undertaking, of course, remains relevant in the market, and, of course, the suppliers integrate in that particular manner. So there are three ex-ante approaches that were introduced in 2019 amendments to the Competition Act. And the first one speaks to issues to do with prudential and reporting requirements. Secondly, we have issues to do with sector-specific codes of conduct. So they are found under Section 24A, 2, and 3 respectively of our Act, and I think we'll be able to dive into each element and understand what role these particular, of course, enforcement mechanisms have played for the authority itself. So around 2021, we had a lot of issues in the retail sector in terms of players collapsing. So the sector associations came together to actually understand where the again Section 24A8 of our Act, together with, of course, the relevant stakeholders, we were able to have a look at the draft code of practice, which, of course, the authority actually gave a force of law in terms of publishing it in the Kenya Gazette. And one of the issues that actually comes out clearly are actually issues to do with fair and ethical dealing, issues to do with variation of contract terms, relevant, of course, purchasing and supplying undertakings, and, of course, duties and obligations of course, parties relevant to issues to do with buyer power. And from our enforcement, I think subsequent to 2021, we were able to, of course, to evaluate, of course, the effectiveness of this code, I think, after some 2-3 years. And I think the findings relevant to, of course, our analysis of course, what the code has done for the sector were positive and also negative on the other side. But the negative ones, of course, I'll be able to explain, of course, how we will be able to, of course, mitigate them going forward. So back in 2020, I think we had over 60% of cases relevant to buyer power cases coming from the retail sector. Post-introduction of the code, we, of course, observed a sharp decline in the number of cases reported. And this is, I think, this is attributed to, of course, the code being in place And we have two codes, two committees actually, steering committees that give life to the code itself. We have the Prompt Payment Committee, which is made up of the sector associations, and of course the Retail Trade Dispute Settlement Committee, which of course has a look at, of course, these particular complaints, the first instance before these, of course, complaints get to us. And that was attributed to the code. And the Dispute Settlement Committee, Retail Trade Dispute Settlement Committee, currently actually is chaired by the Retail Trade Association, Kenya Association of Manufacturers, and also Association of Kenya Suppliers. In addition to these particular players, we have a representative from the Ministry of Trade, a representative from the Office of the Attorney General, and again a representative from the Council of Governors to enable steer forward actually what the committee does itself. So on the negative side, I think from the evaluation of the code, we were able to, of course, decipher that the players in this particular case, the committees, the steering committees that were tasked, of course, with the obligation, of course, to bring this particular document to the attention of these particular suppliers and retailers, generally the stakeholders in this particular sector, we had a reporting that around 45% of these retailers, of course, do not have knowledge of existence of this particular code. And so these are some of the implementation gaps that remain, but there are issues that can be easily implemented through, of course, mitigation measures, issues to do with sensitization, and of course, sensitization, incorporating actually these players whenever we do our activities relevant to the Competition Authority of Kenya. In terms of the second ex-ante enforcement mechanism that the authority deploys in terms of enforcing issues to do with abuse of buyer power is the prudential and reporting requirements. I think that the authority has been able, of course, to operationalize under, of course, Section 24A2 of the Act. And it comes during, I think, the year 2020, when we had incidences of abuse of buyer power arising from one of our retail chains, which eventually collapsed. I believe the Kenyans in the room can remember Tusky Supermarket. I think the same collapsed in around 2020, 21, thereabout. So previously, before the inclusion of this particular ex-ante enforcement mechanism in the 2019 amendments, players will collapse and suppliers will not receive any amounts, of course, subsequent to that collapse. But after we realized an influx of cases relevant to that particular, of course, retailer, we were able to, of course, employ or operationalize Section 24A2 of the Act, which of course gives the authority the powers to, of course, issue these prudential and reporting requirements. And to cut the long story short, I think we were able to salvage over 5 billion Kenya shillings owed by, of course, the undertaking in supplier payments. That is a lot of money. And I think in economics, they indicate that that kind of money getting back to the, of course, these particular market players brings about issues to do with multiplicity effect, which enables these particular players to be sustainable, invest more, pay their employees, and so on and so forth. So we were able to, of course, enforce a debt settlement kind of a mechanism, which was able to, of course, salvage what was never salvaged before, of course, inclusion of this particular provision in our Act. I think we've spoken to that. I've spoken to the challenges as well. So what are the lessons that we've drawn from actually these particular provisions, inclusion arising from the 2019 amendments? We're not indicating that we should completely do away with ex post enforcement. It still comes in handy. But of course, ex-ante regulation, of course, complements ex-post enforcement. And in terms of its flexibility, in terms of actually the market players being actually the drivers of the process itself, because issues to do with codes of practice speak to self-regulation of actually these particular players. And you will realize that the authority is not part of any of the committees that is under, of course, the code of practice itself. So we believe that what we have currently under the Competition Act, CAP 544, offers a model, of course, for other economies that, of course, would want to integrate issues to do with buyer power in their act relevant to, of course, competition law itself. So generally, I think that's it from me, from my end. Issues to do with ex post and, of course, ex-ante enforcement mechanism have to be balanced to ensure that the outcome of course, our enforcement is always 100% whenever we look at the effect in the market. In terms of challenges, I think issues to do with awareness in terms of our enforcement, and also the issues relevant to Section 24 of the Act, issues to do with prudential and reporting requirements, and of course issues to do with sector-specific codes of practice have to be considered going forward in terms of integrating them in our sensitization activities, which again calls for resources to, of course, actualize the same. Asante, thank you.
Okay, thank you, Mr. Robert. Let's give him a clap. We also need to clap for Prosper, which we did not do. Okay, great. We'll go to Dr. Arthur Odima, who will be presenting. He's prepared a paper, and his presentation is on competition regulation and enforcement in digital platforms markets. It's a comparative study of European Union, United States, Africa, and Asia. Dr. Arthur Odima is a Kenyan economist and a competition policy expert currently working with the authority. Dr. Odima, welcome.
So, good afternoon. Yes, so the paper is on regulation of digital markets. It's comparative study across the EU, which is a model for regulating digital market. I've looked at what the US has put in place, South Korea, China, and back home to Africa. So because of the time, I will just speak through. So basically, this is premised on the fact that there are debates that traditional competition enforcement is not tackling the issues that present themselves in digital or online platform markets. So to apply the issues of to define markets, especially digital platform markets, applying the SNP test. This is because of the issues of network effects. These markets are multi-sided. Then the issues of power, I mean, data-driven market power. So this presents challenges to competition agencies. So, and basically we've looked at the models that have been adopted or are under consideration across these jurisdictions. So when we look at, we start with, when you look at the EU is the most advanced. When you look at regulations, the DMA, Digital Markets Act, or that was enacted in 2023. I mean, this presents, it's very detailed in terms of the prohibitions, the criteria for designating a firm or a company as a gatekeeper, and also it has listed the core product services for consideration, actually 10 of them. And when it comes to prohibitions that it has listed, the DMA talks about self-preferencing, the issues of using non-public data to compete, the issues of restricting on interoperability. So those are issues that, and also the EU, it goes ahead to provide for the remedies and penalties, and puts obligations on the farms with respect to, once you realize you meet the threshold of a gatekeeper, then you have the obligation to inform the regulator that you are already a gatekeeper. So you have that obligation. Then when you come to the US, of course, the US, so far it doesn't have specific regulations that targets the online digital platforms, but they are being regulated under the Sherman Act. So, but of course, guidelines, there are drafts that have not yet been enacted. But a number of cases, of course, have been dealt with respect to what they call GAFAM companies, that is Google, Apple, Facebook, Amazon, and Microsoft. And the so likes, the TikTok and so forth. So those such like the big techs, in essence. However, similarly, we note that they've also, the US in these drafts have also given prohibitions, which are more or less similar to what we see in the DMA, that you should not restrict on interoperability, the self-preferencing. Of course, all of you here, you use Google. When you do the Google search, there's always number 1, 2, then you go to, so you will find in the Google adverts, the issue of they advertise their products on the first, maybe 1 or 3 pages. That is what it's called self-preferencing. So you'll see that would apply to Apple if you have an Android, so their apps. There are also restrictions on, you are not allowed, they provide for not restricting one from deleting pre-installed softwares. So those issues are some of the prohibitions. Then, of course, the remedies are also clear in terms of the penalties and how to designate one as a gatekeeper. What I didn't mention is that the EU states that you must have a number of, I think it's 50 million users in 1 year. Then your turnover, it must be, I think, some USD in at least 3 EU countries. So if you look at that model, when we come to China, of course, China digital platforms are regulated under the AML Act. Then their prohibitions are also similar in terms of those the restrictions of self-preferencing. They spell out what you should not do in terms of using non-public data to compete. And then when we cross to the US, the US adds an additional prohibition on tying, where these online platform firms, they tie you to accessing their services to their own, their own services, that before you access this, you must also use our own product, because they are the leading online platforms. So the US mentions about tying as an additional prohibition. Of course, South Korea also uses guidelines to regulate digital online platform guidelines to regulate digital platforms. The prohibitions still the same. So there's a commonality in terms of the prohibitions and in terms of the criteria for gatekeepers. So basically, this paper is to stimulate the discussion on regulating digital platforms in Africa, because, like I'd mentioned, these platforms are all over, including African continent. We've become digital. For instance, in Kenya, almost everybody is online. The Instagram, the TikTok. I think at some point we were talking about influencer markets. That you look at how Google and how competition, these platforms are used for marketing, for selling. So when we come to Africa, I think the most advanced and the most mature country in terms of competition law is South Africa. the analysis of its law, it still uses its act, but South Africa has done a number of market inquiries on online and digital platforms. Of course, South Africa states that it expands its interpretation of the act to accommodate online digital platforms. We are not yet there as Africa. Of course, without mentioning, we can't talk about this without mentioning ACFTA protocol on competition, where they've talked, in Article 11.4 of the protocol, it talks about regulation in digital platforms and states the prohibitions were more or less similar with the model for the EU. But coming home to Kenya, I think our act, I would say it's not adequate to, we try to interpret we've never handled a case on digital online platform services. So we know we are amending the act, we're in the process of amending the act to provide for strategic market position. Of course, we hope the amendments would take into consideration the issues of prohibition, so that we don't have an amendment where what we would call a road leading to a field, or a road leading to nowhere. So we need to be very clear on prohibitions and the remedies and the obligations on these farms once they've been designated as gatekeepers. And this law, we would expect that not just Kenya, but across the continent, as we amend our competition acts, so that we have a very clear criteria and avoid legal ambiguity where we don't state the prohibitions. What do you consider to designate a farm as a gatekeeper or as a co-product service, so that we don't end up with a case and then you say, so what? Yes, so this is the discussion of the paper is stimulating. With respect to recommendation, one of the recommendations I'd put in place is we could develop rules to facilitate regulation of competition in online or digital platform services, because from the Kenyan perspective, rules are enforceable under the Act. Then, of course, we would also just be very clear. I think I've highlighted on the prohibitions and obligations on these firms. Then, of course, market inquiries and studies is also an initial step towards regulating online digital platform services. And, of course, cooperation within the country and across the region. Like if we could cooperate with Communication Authority, then cooperate with the regional and continental competition regulators, because competition in the digital platforms market is a big challenge, and of course through united efforts we would learn from each other and ensure these markets benefit consumers and promote the digital economy strategies across countries in the continent. Thank you.
Thank you, Arthur. We appreciate. So then we'll invite Ms. Irene Macau. Ms. Irene Macau is a Kenyan lawyer, an AI policy researcher and policy strategist. Irene will be presenting on algorithm dominance, so why competition law is the best tool for Kenya's digital dependency. Irene, welcome.
Good afternoon. Good afternoon, everybody. I hate to come between you and your lunch, but please just bear with me. Because I've already been introduced, I would just want to add that I'm also the AI and digital governance lead at ICOYACA, which is the Independent Continental Advisory for the AFCFTM. And my discussion today will be why competition law for the digital markets. And really, Dr. Ada has set the bar very high. He has sort of introduced my paper and what I will be discussing in the paper. And I want to start by saying something that technologies really promise, expansion of markets. But who has power to access that market really depends on who has compute and who has data. Our markets today have moved from traditional to digital, of course, with the promise that they are going to bring everybody in the platforms, they are going to bring everybody on social media, but still, this promise lies a very big risk of exclusion of the very people we want to include, especially for SMEs. And I will be discussing mostly about how, we have talked a lot about monopoly and buyer power and the abuse of that and how that distorts the markets across Africa and, globally. And look, if you used Uber or Bolt or any platform to get here, your price was determined by an algorithm. Your search history, your browsing history, your M-Pesa transactions are constantly surveilled by the platforms to determine what prices they're going to fix for your next ride, for your next purchase. Your adverts are based on your browsing history. Sorry, I'm scaring you. But that is the truth. So the algorithm is a mathematical formula that is behind every system that are driving this e-commerce. And of course, there is a need to regulate these algorithms to ensure that there is transparency and accountability and that consumers of these goods and services that are done through the platforms and the digital social media are not exposing consumers to harm. And one of the ways that it exposes consumers to harm is the self-preferencing that Dr. Ada was referring to, or what is called the Amazon buyout. So ideally what these platforms do, like Amazon, because it has monopoly and it now seeks to abuse the monopoly by only having goods and products that are from its sellers coming or appearing in the platform. So when you go and search from most of these online platforms and digital trade platforms, most of what will appear there is only some of the companies that have monopoly. And this is not, cartels going to the boardroom. We are past that. The cartels are the algorithms. Mathematical formulas that we will not see send emails to each other. Mathematical formulas that are using your data, the same data that you feed there without knowing what is used for, to determine what is your next purchase and how much and what can you see. And you won't be able to see products from your competitors just because these algorithms is built to ensure that you only see goods and products from a specific seller who has monopoly. And now what this means is that when we are controlling mergers, especially as the competition authority, we have to move beyond looking at mergers from a point of who has more money and who is covering more geographical area to who has more data, to who is controlling the algorithm, to who has more compute. Because you will not see these cartels moving and signing agreements to coordinate the prices. It will happen behind closed doors. It will happen through a mathematical formula. So most of the sellers, when they are getting to these platforms, the selling platforms, for instance, let's say Jumia, they will use a price fixing algorithm. And that is coordination. If all the sellers who are in the same field are using the same algorithm to fix the price. But that goes behind the bars. It is very invisible. And in my paper, I will be making an argument that while it's okay to regulate technology on its own, we are still teething with our AI policies, with our AI strategies, and our AI governance mechanisms. The most advanced AI policy or law or framework is the EU AI Act. It doesn't comprehensively touch on algorithms collusions. When we come to Africa, we have the Continental AI Strategy, which has borrowed to our different national AI strategies. They do not cover what algorithm collusion is. And really, when we are talking about AI risks, these risks, I can only imagine of them being classified to two: consumer protection issues and competition issues. That is why I'm making a case that, everything that these digital markets are creating, every risk, is within the mandate of the Competition Authority, is within the mandate of our competition laws. And I'm going to give an example with South Africa. Google. What was Google doing? When you search on Google and you're in South Africa, it would only give traction or traffic on global and international publications and news, and not local news. So you can see what this algorithm does. It reduces visibility of competitors. You will only have visibility over the main tech giants or the main sellers that have monopoly over the market. And you will never have visibility over the local news, over the local sellers, over the local manufacturers. So it reduces that visibility, while at the same time promising that it's been inclusive and that everybody can access the platform and that every seller can advertise in the same platform. Again, Dr. Ada spoke about, the issue of, what is it called? Apart from self-preferencing, there is, let me talk about personalized pricing and advertisement. When I open YouTube, I will see a different advert from you. I'll probably see an advert of a shoe because I was Googling a shoe. You will see a different advert based on what you have been browsing. And even this extends to digital lending. And thanks to the Competition Authority of Kenya in 2021, they conducted a market inquiry on the digital lending economy. And that really revealed how this digital lending economy is very biased. And we cannot expect an algorithm that is trained on historically biased data and biased individuals to produce results that are not biased. And that market inquiry by the Competition Authority really revealed how digital lending apps use the data that you feed, or even your browsing data, or even your M-Pesa transactions to determine whether they are going to give you a loan or not. Predatory lending. They determine the rates based on data that you're completely unaware that is being used for that purpose. Of course, we have our data governance laws, our Data Protection Act, heavily borrowed from the GDPR, that talks about, the use of data and, having consent and lawful processing of data. But these digital platforms and digital economies seem to not fall within the mandate of the Data Protection Act and laws, because they do not comply to that. And I think my paper is a call to the Competition Authority to conduct more of these market inquiries to digital platforms, all the digital platforms and social media platforms and tech giants, to just be able to learn the algorithms. Make sure that the algorithm that is behind every system is explainable. Audit the algorithm. Make sure it's explainable. Make sure there is a human reviewer for every decision that is made by an algorithm. And this is a requirement by the Data Protection Act. So I am not very aware why, some of these digital platforms do not seem to lie under this mandate. But really, it's because we can say that our data protection laws and their AI policies are very new. And our competition laws are something that we can really rely on to, sort of ensure that they are compliant. And lastly, I'll talk about the recent COMESA regulations 2025. I'm really glad that they are trying to bring this untapped digital market that is always falling outside the regulations to its mandate. To just ensure that, this economy that is always, having a lot of profits from our countries also respects consumers and also respects competition. Of course, we are not afraid of, having big companies that have monopolies within us. That is a good thing, but at least let the grounds be very plain for everybody, from SMEs to every big company, without algorithm collusions price references, and all those problems that are coming with the use of algorithms and data monopolies. So for me, this is a call to the Competition Authority to, be able to collaborate with other stakeholders like the Communication Authority, researchers, to just ensure that we have evidence-based regulations that ensure that our digital market remain checked, because they determine who has access to what, who has access to lending, what kind of services I can get, and at what price. I think that's all I can say.
Okay, let's give a clap. So we are moving on quite well. Our speakers have kept their presentations to 10 minutes. We'll move to Dr. Vela Kigwiru. Dr. Vela Kigwiru is a competition law and policy expert and an academic researcher. Her work focuses on competition policy issues in Africa. And Dr. Vela has done a paper on assessing a digital platform's personal data processing terms of use as a competition law violation. Dr. Kigwiru, welcome.
Thank you so much.
There's a presentation for Dr.
Yes.
Vela.
It's so this is so exciting to hear from the previous speaker and to just know that we have experts here who really understand the regulation of digital markets, and I'm so happy about it. I recently published a paper on the goals of the FCFTA digital market regulations, which you can have a look, that speaks to all the issues that they have addressed. So today I want to talk about a very important topic, and I see most of you are on your phones. And I don't know how much data you're sharing so far. And if you understand what data you're supposed to share, what is personal data and what is not personal data. And if you really understand what are cookies, are you just accepting all cookies, or are you accepting functional necessity? How are you using your data? Data about your children, data about your family, and how is this data being used in the digital landscape? So for a long time, the issue of data protection emanates from the issue of, where should I? This side? The middle one. Okay, super. So for a long time, the issue of data protection was being governed by privacy laws and data protection laws. It was not a competition law concern. And the EU Court of Justice had made it very clear that the issue of data protection was not a competition law concern. But in 2019, the German competition agency that enforces the German competition law, known as the Bundeskartellamt, made a paradigm shift. And in this case, Facebook, which is now part of Meta, had given conditional access to users of Facebook that if they were to use Facebook, they had to allow Facebook to combine data on Facebook and off Facebook, that is from third-party websites. And the Bundeskartellamt argued that that conduct alone constituted an abuse of dominant position and had to prove why this was a competition concern in addition to a data protection concern. So this was the first ruling ever for a competition agency to look into data protection issues. And since then, we've had the Nigerian Federal Competition and Consumer Protection Commission, Brazil, Chile, India, and other countries looking at data protection issues as competition concern. And the question I'm trying to address in this paper is, when does a data protection issue become a competition issue? Because one, we don't want to have competition agencies that are intruding into other regulatory realms of other regulatory authorities. So in this case, we are going to avoid jurisdictional conflicts and also conflicts of laws. And also, we don't want to add an additional cost to businesses to be complying with different institutions at different levels. And in some cases, we can also have conflicting decisions from two institutions. So when does a data protection issue become a competition law concern? So the first thing for competition agencies, they first have to understand data protection law. In the case of the German Bundeskartellamt decision, which I'm using as a case study, the issue was about the issue of consent. when can you literally say that you've given a platform a valid consent? And our data protection law under Section 4 and Article 11 of the General Data Protection Regulation of the EU provides for 4 key elements. That your consent should be freely given. It means that you've made an autonomous choice to give that data to that platform. And this autonomous choice is negated when we have a detrimental withdrawal. For instance, you are indicated that if you withdraw, you will not be able to access that service. Or in other cases, if you don't consent, you start receiving a lot of cookie pop-ins that leads now to consent fatigue that you literally just accept. Or maybe there's no other alternative. You remember the time when WhatsApp had issues and it was so difficult for us to move to, what is this other platform? I just forgot the name. It was Signal. It was very difficult to move to Signal because most of your friends, most of your family and other users are on WhatsApp, you want to be there. So it becomes so difficult. The consent also has to be specific. If a platform is getting you data and it's only for the purposes of registration, they should only use it for that purpose of registration. You should also give informed consent. That means they give you adequate information to know whether you're going to give your consent or not, and it has to be very explicit or unambiguous. The issue of just ticking already boxes, that is not really informed consent. So that is what we understand by the concept of that. So the debate has been whether there's a causal link between data protection and competition law, which for me, I find it not the right way to do so, because it's like you're telling a competition agency to determine whether there's a data breach. No, that is the role of the data protection agency. The competition authorities are supposed to determine whether there are competition concerns that are arising from data protection issues. And that is exactly what this paper is trying to do. So I come up with what I call a competition-oriented approach to determining data protection issues as competition issues. The first one, as my colleagues have said, data is now the oil of the digital landscape. Data gives platform what we call data power. They have the access to data flows. They control that data. Sometimes we argue that there's portability of data, but it is for the platform to determine whether it will share that data with other platforms. And that is why under the Digital Markets Act, they're pushing for interoperability. Data also increases other sources of power. The market power, gatekeeping power, intermediary power, digital ecosystem power, whereby digital platforms are not just having one market, but they're also leveraging into other adjacent markets. Look at Meta. Meta has the Facebook, it has the marketplace, it has Instagram, it has WhatsApp, all this, and then it has interconnected services within this market. So once a competition agency can determine that data is a non-price metric of power in digital platform, then that becomes an issue that the competition agency can look at. But it doesn't stop there. We must have a competition law violation. It can either be an exclusionary conduct, because the more a platform has data, it can create barriers to entry if other platforms cannot access that data. So it becomes an exclusionary conduct, or an exploitative conduct in a way that, is it an excessive data collection? Is it leading to unfair trading conditions as well? The third one, after that, there's also a legal test I'm going to show in other slides. When do you say that this is an excessive data collection? When does legitimate data collection stop and excessive data collection begin? It's not easy for competition agents to find that. And most importantly, is there a competition harm? How do we measure competition harm in absolute terms when it relates to data? Because in competition law, we look at price, we look at the cost. But when does data become a competition harm? And most importantly is the issue of causality. In competition law, we have what we call the conduct causality and the result causality. Conduct causality is very strict. You have to show that were it not for that conduct, then the consumers will not have suffered that harm. It's not about having a dominant position. It's about the specific conduct. As the previous speakers have clearly noted, that having a dominant position is not illegal. Abusing it is illegal. So that is an approach. So I've talked about, I don't know how to go back. Which one? So the first issue of data as a source of data power, which leads to market power, is very clear because of the market characteristics. The network effects, as Arthur has talked about, is all about the value of a platform increases with the number of users that are on that platform. All of us want to be on Facebook. We have the young generation that just want to be on TikTok because their friends are on TikTok. So the businesses want to be on TikTok because they're able to access users. So it leads to a lock-in effect. So that if you're a new entrant into this market, it's not easy for you to enter into this market because you cannot access the users. You cannot access the data about users. So this is one of the issues that competition agencies should look into. The second one, we talked about what is the competition law violation. So when you look, some of the organizations have been looking at excessive data collection akin to excessive pricing. But there's a lot of conceptual and practical challenges relating to how to measure excessive data collection. In excessive pricing, we look at the cost of product. So when you look at the cost of production of the product and you look at the price of the product, there's no reasonable relationship. It seems like the organization or the company is just making profit because it has a competitive advantage. But then, is data akin to price? Some will argue yes, others will argue no. Those are some of the challenges that face. And then how do you measure excess? As a competition agency, when do you determine that this is excessive data collection, this is not excessive data collection? These are some of the challenges that competition agencies are facing. And another one is, if you say that it's unfair trading collection, which is very, this is a term, when you talk about fairness, it's very elusive because sometimes it's personalized. So in Europe, they have looked at, you look at the terms. For example, if there is a conditional consent and there's no alternative, then you can argue that that is an exploitative conduct. So you look at, you access this rights and this obligation qualitatively and not quantitatively as it comes to excessive data collection. So harm, most of the time we look at choice, we look at prices, maybe the cost of product is too high. So for the competition agencies that have addressed this issue, they have looked at the issue of limited choice, because if there's no other reasonable alternatives in the market, then you don't have a choice. Then you just have to be on Facebook, or you just have to use Google Maps because there's no other alternative choice. And another one is quality degradation. That is when there's detrimental withdrawal. There are other cases, like in the Nigerian cases, where Nigerian users were given an alternative that was not the same as what the EU users were using. And the other one is just there's no other alternatives, there's no opt-out options. So most of the time they have looked at the quality degradation and autonomy, and it's argued that limited choice is one of the competition objectives, and also service quality is one of the competition objectives. So we can literally say that this leads to competition harm. The causality requirement, it depends with jurisdiction. So the EU, not the EU, the German Bundeskartellamt used the result causality, whereby they don't look at the conduct to have led to harm, but the result of your conduct. We look at it in detail. I'm very sorry we don't have time. So this was the main issue. So I'm using the German case because when the German Competition Agency made this decision in 2019, Facebook appealed it to the regional court. And the regional court made a decision that did not accept the competition agency. And then it now moved to the Federal Court of Justice, where it overturned the regional court. And then it moved to the European Court of Justice. So when you look at this contestation between the courts, you are able to understand why this is a very important issue. So for the German, they made it clear that data entrenches market dominance, and that the prohibited conduct was excessive data collection and fair trading terms. And how they measured it was that the data that Facebook was collecting from third party was not necessary for the provision of social networking on Facebook. It was not important for it to get the data from Instagram or other third-party websites. It was not necessary. And then the harm was, of course, diminished quality and limited choice and the result causality. So this is the most important aspect of this paper. the Oberlandesgericht, which is the regional court. In this court, after Meta appealed, or Facebook appealed, by that time Facebook had not changed its name to Meta, it argued that that data was never excessive, and the German competition agencies failed to prove evidence that additional data for Facebook was not necessary for the performance of its contract. And also, it did not use competition tests, for example, as if competition, to look at other providers in the market and literally say that what Facebook was doing was wrong. And also, the argument that German users did not have a choice did not fit. Why? There was a survey that the competition agency had done, and 46 of Germans had literally indicated, like out of the 55 million, 30 million of Germans were using Facebook and the other were not using, like, of course they have a choice. They have, because they were on other platforms. So, and they said that in this case, it has to be a conduct causality. The Commission agency has to show that were it not for those data processing terms on conditional consent, then the users will not have, it will not have harmed consumers in a way that they did not have limited choice or there was degraded quality. And therefore, the German moved now, the competition agency now moved to the Federal Court of Justice. This is where now the competition issue begins. For the Federal Court of Justice, they decided to look at the competition issues, whether that conduct of conditional consent to share data and combine data on Facebook and third-party website was indeed a competition concern. They looked at it as an exclusionary conduct because it created a barrier, because the users did not have another alternative. So it was that issue of creating into a barrier that it became a competition issue. And they also agreed and dissented with the regional court that the German users did not have a limited choice. They said they indeed have a limited choice. And indeed, after that survey, the German users said if they had another alternative where it could collect less data, they were ready to pay. And now when you open your Facebook page and you're asked, are you consenting or you want to pay, the pay or consent model, I think most of us have seen that. That is what is emanating from this. If there was another alternative that would collect less data, and they were willing to pay for this. And therefore, they said, when it comes to causal requirement, it doesn't have to be a strict causal requirement. And a result causal requirement can suffice because in these cases, when you look at the market conditions of digital market, and if there was indeed effective competition within that market, then one would say that when there's an effective competition, then that conduct will not have happened in that market. So in this case, you can literally use causal result causality. And this is exactly what happens from this decision. Yeah, at that time now, the EU Digital Markets is enacted, and you see these decisions now coming into the Article 5.2 of the EU Digital Markets. And you can see the issue of regarding choice, product quality, and the EU DMA stating exactly in Result 37 that platforms should be able to give users an alternative service that does not have degraded quality. And that's when we start seeing the issue of pay or consent happening. I'm being told I don't have time, despite this being an interesting, so we are on the last slide. Being an extremely interesting topic because it affects you, and the fact that you give a lot of data to these platforms, it really calls for the competition agencies to see to what extent they can intervene without intruding into data protection issues. And also Article 11.4H of the FCFTA Commission Protocol also prohibits designated digital gatekeepers from combining personal data from different platforms. So this final decision from the Court of Justice introduced a number of principles, and they indicated that indeed, competition agencies are not supposed to intrude into the role of data protection agencies, but then we'll be making a very bad assumption to think that data is not a source of power. So data can be used as a vital clue for abuse of dominant position. It can be used as evidence. It just depends on how the competition agencies will look at. But then if Firms, digital platforms have to have a defense because some of us maybe will represent in businesses. They have to show that the use of that data was objectively indispensable in that without that data, they were not able to provide a service. Secondly, there was no less privacy intrusive alternative. And third, users had a reasonable expectation that the platform will use its data for advertisement and other issues. And of course, they agreed that limited choice, quality, competition harms that can be found. And then they said that when it comes to causal requirement, dominance is necessary, but it's not sufficient. So it is for the competition agency to determine whether there was indeed an abuse of dominance in competition-related issues. So what are the key takeaways? And one of the things I love about the German Bundeskartellamt, because I also live there, is that now when you look at your meta products, all of us, if you go to Facebook or you go to WhatsApp status, if you have to share your data, even what you are posting on WhatsApp, you have to give consent to that. That is why we have the meta account, so that you can decide whether if you post on Facebook, it can still appear on Instagram and so on. And this is now what we are calling the design remedies, pushing these digital platforms to provide these remedies within their design products. I'm sorry for the time, I'm done.
Thank you, Bella. Yes, we'll get back to you in the afternoon. So let's make sure we reach out to her in the afternoon for more information, because there's interesting conversations coming out of this breakout session, not just on the data issues, but on the digital platforms, the issues of buyer power. We have one last presentation, which is online by Ms. Sifosethu Tetani, who has done a paper with Mr. Itumeleng Lesofe. I don't know whether they are online. The paper is on market power dynamics and the competitive landscape in South African digital markets. I'm sure they are online, Tim. Sorry? Okay. Sifo, please switch on your mics.
Good afternoon. Good afternoon, please.
Good, you may proceed to present.
Thank you so much. I'm trying to project my presentation.
Please unmute. We cannot hear you.
Oh, sorry, can you hear me now?
Yes, you may proceed.
Okay. So as a form of background for this paper,
Yes, because of time limits, we'll limit the Q&A to just 3 questions. So I'd like to see Hans, first question, but the second one I'll just choose from any random table. So just to test whether you've been listening. And the third one, yeah, so first question.
I have a question for Dr. Dima. How do you think the sort of Digital Markets Act type access could apply in African countries? And specifically Kenya, we heard on the previous panel that access to M-Pesa, for instance, has been on the table for some time, but and there's interoperability, but it's quite expensive and it's not seamless. There's some data sharing. I really like your paper, by the way, but it's not. But it's at an enormous exploitative cost, as you were saying, to the digital lenders who use the M-Pesa transaction data and then charge 30-odd%. And so those just a question about how do you see that the sort of regulation of access to digital financial services providers like M-Pesa, how could that work, or how could that be translated in Kenya? Thank you.
So you need to introduce yourself.
I'm Ryan Hawthorne. I'm an economist at Acacia Economics. We have a grant from the Gates Foundation to study competition in markets for digital financial services, including in Kenya. So that's where.
Okay, we'll pick up the questions, then you can answer. So I said the second one I'll just pick randomly. You'll be the third one. The second one I'll just pick randomly. So I hope you've all been listening. I see people avoiding my eyes.
All right, thank you so much. My name is Tabitha Kiendi. I am from Feather Capital Advisory Group. I'm the head of transaction advisory. And my question goes to Sifo Sedu. You mentioned regarding the property section that there is over-reliance on Google, that most people do their property searches in Google rather than going to the website directly. But then again, is it Irene who mentioned that right now there is an algorithm per se, what dictates, So there is many things that have come up. There's the AI, there is ChatGPT, Gemini, Claude, DeepSeek, all sorts of things. So my question, I think, is to either one of you, if that has affected the logistics, the loyalty, traffic share when it comes to property. Thank you so much.
Okay, thank you, Mr. Tosha. This is the last question.
Sure. Thanks. My name is Isaac, and I'm from Kwadzi. Just to appreciate the colleagues for a very good presentation and very informative. But I do have, I consider them silly questions because some of the things are known. But I wanted to appreciate that the legal system we have normally points at a legal or juristic, is it correct, person. So I heard you talking about algorithms coming up and then in a way leads to collusion somewhat, okay? So now the question is, how do you pin down algorithms, okay? As competition authorities, we want to find people, if we find them on the other side of the law. So now if it's algorithms, how do we do it? I told you already it's a silly question. So please just consider that. So I have to end here. Okay, thanks.
Yes, thank you, Ryan. When we try to, my thinking with respect to bring the EU or the DMA to Kenya would be with respect to the strategic market position, which I think we are trying to include, we have included in the amendments. So in this, you would expect that we define a gatekeeper, the criteria for saying this firm is a gatekeeper in Kenya, in this, in the digital product market, or we say these are the core product services that if a firm provides, then the strategic market position would apply to that firm. Then we would also provide the prohibitions that firms know in advance that they are prohibited from engaging in ABCD, so that it's very clear from the onset. And lastly, I would expect that in the strategic market position provisions, we provide for obligations on firms once they determine themselves that I'm a gatekeeper, of which being a gatekeeper is not an offense. But once you have been designated as a gatekeeper in Kenya, then you have certain obligations that you have to adhere to. That would be my approach to jumpstart the process. Yes, thank you. And of course, you know, firms that provide core product services in Kenya. Yes, thank you.
So, Irene, do you want to take the second question from the lady who was there?
I can take his question.
Okay.
I think I missed something on our question. So I already know my next research topic, apportioning liability for algorithms. And really, just apportioning liability for AI systems is very problematic. But what really are algorithms? They are mathematical formulas that are created by people. They are created by companies. And if we have to apportion liability, then it has to go back to the creator of the system. They know that the algorithm, the formula exists, but they are not disclosing. They are not ensuring that there is accountability and transparency and continuous audit of the system to just ensure there are no errors and biases. So really, we go back to the creator of the algorithm. Of course, there was another argument that was when AI systems cause harm, it should be apportioned between the creator of the system and the person who prompted the system. Because really, based on how you're prompting the system, is how you're going to get an answer. So, still very gray. I'm not sure if I've really answered your question very well, but the creator company, and in some cases, the company and the person who prompted it. I know that is controversial, but yeah.
Maybe you could have C4. There was a question for C4. You could take it up, then we could also allow Vela to address the aspect of what Isaac was asking in addition to what Irene was addressing. So C4.
Thank you so much. It's actually C4 saying too. So on the question of if whether or not the ALC is affected by AI or Google. So when the Commission conducted, CCSA conducted its market inquiry, it looked at what influences the search outcomes on Google. And we found that part of those influences were actually AI, but also there was a big influence by capital. So the pay for search and search optimization was a big factor in terms of the search results in South Africa specifically. So companies paid to be the first to appear on Google search results. So then the companies would bid on specific terms. So for example, they would bid on property and housing. So anyone who searches then for housing and property, the largest bidder would then get to be the first in terms of the results from search. So then after the market inquiry, then there were recommendations that, remedial actions that were put on Google by the Commission in terms of how the search results should be optimized on Google, how they should be responsive to the search instead of just prioritizing the leads and who has money then to pay to be the first on the search results. So as much as there could be a possibility of that influence in terms of AI, but there's also some regulation that has been put in place by the Competition Authority in terms of how Google can influence competition. Thanks.
Okay, thank you, Sifosethu. Vela?
Thank you so much. I thought she was better positioned to talk about the algorithm collusion, but I think he asked about how can they find out. And one of them is if you have the power, because it's all about the power, to compel the parties to produce that information during investigation, or also to also invest in your own digital surveillance tools on the other side. So it really depends on power. And also to push for product design, so that some of these remedies are installed in the product design of this platform. That's why we are talking about the Meta account design on Meta that allows users to make a decision on whether to share information. Just allow me in 30 seconds to comment on the issue of the EU. I find that the EU Digital Markets or the UK Digital Market and Consumer Protection Act, those are ex-ante regulations. And for developing countries, we have to really take a cautious approach in copy-pasting some of these provisions, because one of our key objectives in our markets is innovation and investment. That's why you're talking about the fintech industry. Would like our businesses to expand, to regionalize, to participate in the continental market under the FCFTA, and also to compete in the global trade. So we don't need to have very strict rules that can stifle their innovation and expansion. So even when he talks about the strategic market status, that is a very different concept from the designation of digital gatekeepers under the EU digital markets. Strategic market status is found in the UK digital the DMCCA, and because they didn't want to use the concept of designated digital gatekeepers, the issue of core platform services, the Kenyan Amendment Act does not talk about designation of gatekeepers. It talks about digital activities, which also very different. I've just done a write-up in some of the cases before the EU Commission that have been contested by platforms on what exactly is a gatekeeper. When do you say that this activity is a core platform service? It's because it's providing a commercial getaway or a professional getaway. When it's between end users, it doesn't fall under the scope of the DMM. So those are just some of the issues. That's why you see when COMESA initiates investigation against the Meta AI, they use the abuse of dominant position under Regulation 36 of the new regulations, and not under Regulation 38, where they're trying to regulate gatekeepers, because every word, if you see a gateway, you really have to prove, because the platforms are ready with their defense. And recently, the EU Court of Justice has just made a decision against the EU Commission for designating Facebook Marketplace as a core platform service. So you see, those are some of the issues we really have to look into. Thank you.
Let's give them a big clap. This was a good panel. We really appreciate. So I'm sure lunch is served now. We've all gotten some cards, but the panel will take a photo.
So good afternoon, ladies and gentlemen. My name is Sylvester, and I'm here just to make a few announcements. Number one, as the committee indicated, we are going to have a lunch at Lelai Restaurant on first floor. We'll have our colleagues out there maybe to give you direction. Then ensure as you go there, you carry your meal voucher, and we intend to reconvene at 3 p.m. So enjoy your lunch. Thank you very much.
You can now file consumer complaints regarding, among others, misleading representations, unconscionable and unfair conduct, and the sale of unsuitable or defective goods to the Competition Authority of Kenya through our e-filing portal. Do you have all the evidentiary information relating to the contentious transaction, such as warranties, receipts, and contracts? Have you sought redress or assistance from the seller or service provider in question with no positive outcome? If the answers to these questions are yes, start the online process of filing a consumer complaint by creating an account on our e-filing portal. Upon registering, log in and on the dashboard, select File a Complaint, then pick the Consumer Complaint option from the resultant drop-down menu. You will then be required to provide the name of the accused party and a narrative of the complaint under the complaint details. Kindly be as clear and precise as possible in your account. Attach your supporting documents by clicking on Browse and choosing the relevant supporting documents, which may include receipts, contracts, warranties, and invoices. Upon submission, the portal auto-generates a response confirming that the authority is in receipt of your complaint. You can track the progress of your complaint from the portal's homepage. Billy's top tip regarding consumer complaints: always retain your receipts, warranties, contracts, and other forms of proof of purchase. To learn more about our consumer protection mandate, visit our website www.cak.go.ke. Competition Authority of Kenya, creating efficient markets for consumers. Agreements, decisions or practices between competitors that seek to fix prices, limit output, share markets, customers or sources of supply, and other cartel behavior, such as bid rigging, are regarded as harmful to competition. Such conducts threaten the foundations of free market economies and are therefore punishable under the Competition Act of Kenya. However, there are instances where agreements or collaborative practices between competitors can prove beneficial or obtain benefit for the public. In such instances, the Competition Authority of Kenya is empowered by the Competition Act to grant exemptions that allow such agreements so long as they: 1. Maintain or promote exports. 2. Improve or prevent a decline in the production and distribution of goods and services. 3. Promote technical or economic progress or stability in an industry. And 4. Obtain a benefit for the public which outweighs the lessening of competition that the practice occasions. Further, the authority may, upon application, grant an exemption in relation to any agreement or practices concerning the exercise of intellectual property rights and professional association agreements as provided for under Sections 28 and 29 of the Competition Act, respectively. If as a business you believe that particular collaborations or agreements will result in greater public good when compared to the negative impact on competition, you can make an exemption application through our e-filing portal. Start by creating an account on the portal. Click on Register and enter the respective details as directed by the platform. Once registered, log on to the system and click on the menu button, followed. Competitive markets lead to improvement in quality, innovation, and better prices, resulting in great value for consumers. To enhance competitive markets, the Competition Authority of Kenya is mandated under the Competition Act to regulate mergers and acquisitions. Once businesses have identified a party or parties they wish to merge with, whether in whole or part, they have to file an application with us, the Competition Authority of Kenya. We have made the notification process wholly paperless, so you can conveniently file from anywhere in the world and at any time. To start the process, simply log into our e-filing portal, click Register and provide your credentials as directed by the platform. Once registered, log on to the portal and click on the menu button and select Mergers on the resultant selection panel. Type in the title of the proposed merger and click Save. The portal will auto-generate a special filing number, which will be promptly sent to the email address you provided when registering. This unique number will be used for any subsequent filing regarding the proposed merger. Once all parties to the merger or acquisition have the filing number, you are ready to fill in the merger notification form. To open the merger notification form, click on the plus sign under the merger party filings. The instructions in the form will enable you to ascertain the nature of the transaction being filed. The merger notification form has 4 schedules. Schedule 1 contains the mandatory information required for any filing. Where a mandatory field is not applicable to you, a filing party, kindly indicate not applicable. The attachments accompanying this schedule are mandatory. Where a mandatory attachment is not available for your filing, attach a detailed letter and an affidavit where necessary, detailing the reasons for their absence. This may, for instance, refer to a scenario where audited financials are unavailable. Schedule 2 of the merger notification form details the products and services supplied by each of the filing parties, while Schedule 3 covers the horizontal and vertical relationships of the merging parties. Finally, Schedule 4 is a mandatory declaration form which all parties must download, fill, scan, and attach. At any stage of the filing, you may save your work and pick up the process later. Clicking the Submit button, however, indicates that you have verified your submissions. You will not be afforded a chance to edit the same. Upon submission, the portal auto-generates a PDF version of the submitted information with a timestamp, indicating the time and date the merger notification was submitted. Users can click to download this PDF for their custody and reference. The same PDF is also emailed to the registered email addresses. The portal also enables you to track the progress of your notification from the homepage. Top tip from your man Billy. Ensure all submitted documents are in English, clearly legible, and are in PDF format. For this and other tips on how to file for a merger or acquisition, visit our website www.cak.go.ke. Once your merger notification form has been received, the authority conducts an in-depth analysis of the impact of the proposed merger or acquisition on competition and public interest concerns and issues a determination. The authority can approve the application unconditionally with conditions or reject it. The authority is also empowered to impose penalties and/or initiate criminal proceedings against parties who implement mergers without approval. If you're still unsure about the process of notification of a proposed merger, you can, for free, seek an advisory opinion from the authority. Competition Authority of Kenya, creating efficient markets for consumers. Free and fair markets are key to economic growth and sustainability. The Competition Authority of Kenya is charged with the responsibility of promoting and protecting effective competition in the Kenyan market and preventing misleading market conduct. Our main objective is to enhance the welfare of Kenyans through ensuring that businesses operate in open and competitive markets, which guarantees access to innovative and quality goods and services that are competitively priced. Under the Competition Act No. 12 of 2010, restrictive trade practices are prohibited because they prevent, distort, or lessen competition in trade. Examples of anti-competitive practices include price fixing, bid rigging, customer and market allocation, abuse of dominance, and maintenance of minimum retail prices. These anti-competitive practices may involve businesses at the same level in the supply chain. This is referred to as horizontal relationship. Additionally, businesses in a vertical relationship, for example, a manufacturer and a distributor, may also engage in practices prohibited by the Competition Act, such as exclusive market allocation. Parties found culpable of infringing the competition law may, following a criminal prosecution, be imprisoned for a term not exceeding 5 years, a maximum fine of 10 million Kenya shillings, or both. The authority may also administratively impose a penalty of up to 10% of the undertaking's preceding year's turnover. Are you aware of businesses engaging in restrictive trade practices? You can report them to the Competition Authority through the e-filing portal. Simply log into the portal, click register and provide your credentials as directed by the platform. Upon registering, log in and on the dashboard, select File a Complaint and pick Restrictive Trade Practices Complaint option from the resultant drop-down menu. Proceed to populate the online form, including filling the details of the person or undertaking making the complaint and details of the accused party. Kindly remember to title the complaint. We have also provided an allocation for you to attach documentary information relevant to the complaint. You may upload as many documents as you wish. Ensure that you have reviewed all the documents for accuracy and that they are all in PDF format. Once satisfied that you have provided all the information, you can click the Submit button. Upon submission, the portal auto-generates a response confirming receipt of the application by the authority. The portal also enables you to track the progress of your complaint from the homepage. Top tip from your man Billy. The authority has in place an informant reward scheme which offers financial rewards to persons who furnish the authority with credible information, resulting in penalization of firms engaging in anti-competitive conduct. Prospective informants can contact the authority by emailing informant@cak.go.ke. For more information regarding restrictive trade practices and the informant reward scheme, kindly visit our website www.cak.go.ke. Competition Authority of Kenya, creating efficient markets for consumers. Picture a scenario with two business entities, one which buys and sells goods to final consumers, and the other, the supplier of the goods. The situation could also involve buying and selling of a service. In some instances, the buyer may have such a significantly superior bargaining position that they are able to control the nature of the commercial relationship between the two. Having buyer power or a superior bargaining position is not an offense. However, abusing that power by engaging in practices such as delaying payments, unilateral termination, or threats of termination of contract without notice, refusing to receive goods despite having ordered them, and transfer of costs and risks to suppliers is prohibited by the Competition Act. So, if you're a supplier facing abuse of buyer power, or a concerned citizen who is aware of such practices in the Kenyan economy, there is a way out. You can now conveniently and efficiently lodge an abuse of buyer power complaint or submit information on abuse of buyer power for investigation by the authority. The service is offered free of charge. To start the process, simply log into our e-filing portal, click register, and provide your credentials. Upon registering, log in and on the dashboard, select File a Complaint and select the Abuse of Buyer Power option from the drop-down menu. You will then be required to provide the name of the accused party and the nature of your complaint and the complaint's details. Kindly be as clear and precise as possible in your account. Attach your supporting documents by clicking on the Browse tab and choosing the relevant supporting documents. Before clicking Submit, ensure that the information and attachments are verified and in order. Be careful to only upload the attachments in PDF or JPEG formats. Upon submission, the portal will auto-generate a response confirming that the authority is in receipt of your complaint. You can track the progress of your complaints from the portal's homepage under My Cases. Remember, parties found culpable of infringing the competition law may, following a criminal prosecution, be imprisoned for a term not exceeding 5 years, a maximum fine of 10 million Kenya shillings, or both. The authority may also administratively impose a penalty of up to 10% of the undertaking's preceding year's turnover. Another top tip from your man Billy. As a buyer or seller, always insist on signing and retaining written agreements and contracts which clearly outline the terms of trade. To learn more about the authority's mandate of sanctioning abuse of buyer power, kindly visit our website www.cak.go.ke. If you require further clarification, you can also seek an advisory opinion from the authority. We offer this service free of charge. Competition Authority of Kenya, creating efficient markets for consumers. Hi, my name is Billy and I'm here to talk to you about the Competition Authority of Kenya, CAK. The Competition Authority of Kenya is a statutory agency established under the Competition Act No. 12 of 2010. The authority's mandate is to enforce the Competition Act with the objective of enhancing the welfare of Kenyans by promoting and regulating effective competition in markets and preventing misleading market conduct. Our core mandate is to control mergers and acquisitions, protect consumers from unfair and misleading market conduct, and sanction anti-competitive practices and abuse of buyer power. Additionally, the authority advises the government on matters relating to competition and consumer welfare. In order to enhance its efficiency, And in line with the government's agenda of increasing the use of digital platforms in service delivery, the authority on September 1st, 2020 ceased receiving physical applications relating to its technical processes. All applications must be lodged through the authority's e-filing portal, which is accessible via the link that is on your screen now. To enable our stakeholders efficiently use the e-filing portal, the authority has developed and uploaded user manuals, which can be accessed on our website www.cak.go.ke. Alternatively, you can access the tutorials on our YouTube page by searching for Competition Authority of Kenya on the platform. Any stakeholder facing challenges accessing or operating the e-filing portal can channel their feedback to the authority through the dedicated email e-filing@cak.go.ke. The authority can also be contacted via our number +254 20 277 9000. Competition Authority of Kenya, creating efficient markets for consumers. The Competition Authority of Kenya now offers an easier and legal way to address disputes where your rights as a consumer have been infringed by a supplier of goods or services. Our complaints handling mechanism doesn't involve long queues, shouting matches, or cumbersome paperwork. And to top it all off, this service is available absolutely free of charge. Yes, you can now file consumer complaints regarding, among others, misleading representations, unconscionable and unfair conduct, and the sale of unsuitable or defective goods to the Competition Authority of Kenya through our e-filing portal. Do you have all the evidentiary information relating to the contentious transaction, such as warranties, receipts, and contracts? Have you sought redress or assistance from the seller or service provider in question with no positive outcome? If the answers to these questions are yes, start the online process of filing a consumer complaint by creating an account on our e-filing portal. Upon registering, log in and on the dashboard, select File a Complaint, then pick the Consumer Complaint option from the resultant drop-down menu. You will then be required to provide the name of the accused party and a narrative of the complaint under the complaint details. Kindly be as clear and precise as possible in your account. Attach your supporting documents by clicking on Browse and choosing the relevant supporting documents, which may include receipts, contracts, warranties, and invoices. Upon submission, the portal auto-generates a response confirming that the authority is in receipt of your complaint. You can track the progress of your complaint from the portal's homepage. Billy's top tip regarding consumer complaints: always retain your receipts, warranties, contracts, and other forms of proof of purchase. To learn more about our consumer protection mandate, visit our website www.cak.go.ke. Competition Authority of Kenya, creating efficient markets for consumers. Agreements, decisions or practices between competitors that seek to fix prices, limit output, share markets, customers or sources of supply, and other cartel behavior, such as bid rigging, are regarded as harmful to competition. Such conducts threaten the foundations of free market economies and are therefore punishable under the Competition Act of Kenya. However, there are instances where agreements or collaborative practices between competitors can prove beneficial or obtain benefit for the public. In such instances, the Competition Authority of Kenya is empowered by the Competition Act to grant exemptions that allow such agreements so long as they: 1. Maintain or promote exports. 2. Improve or prevent a decline in the production and distribution of goods and services. 3. Promote technical or economic progress or stability in an industry. And 4. Obtain a benefit for the public which outweighs the lessening of competition that the practice occasions. Further, the authority may, upon application, grant an exemption in relation to any agreement or practices concerning the exercise of intellectual property rights and professional association agreements as provided for under sections 28 and 29 of the Competition Act respectively. If as a business you believe that particular collaborations or agreements will result in greater public good when compared to the negative impact on competition, you can make an exemption application through our e-filing portal. Start by creating an account on the portal. Click on register and enter the respective details as directed by the platform. Once registered, log on to the system and click on the menu button followed by exemption application on the selection panel. The form has instructions on what should be filled based on the nature of the information needed. You should read these instructions before proceeding to apply for an exemption. Ensure all fields in the exemption application form are populated, that is, none should be left blank. Also, ensure that the information and attachments intended to be submitted to the authority is verified and is in order. Download the Declaration Schedule Exemption Application Form provided as a hyperlink on the exemption application form, fill it and upload it in PDF format. Any other relevant attachments including, but not limited to, agreement subject to the exemption application and the confidentiality claim form should be attached once they have been filled in. After verifying that all required fields have been filled and all attachments are in order, click Submit. Upon submission, the portal will auto-generate a response confirming receipt of the application by the authority. The portal will also enable you to track the progress of the case from the homepage on login. Remember, parties found culpable of infringing the competition law may, following a criminal prosecution, be imprisoned for a term not exceeding 5 years, a maximum fine of 10 million shillings, or both. The authority may also administratively impose a penalty of up to 10% of the undertaking's preceding year's turnover. Finally, a top tip from your man Billy. Where businesses are unsure whether an agreement is likely to negatively affect competition, they should seek an advisory opinion from the authority. Advisory opinions are offered free of charge. For this and other top tips on what is applicable for an exemption application, visit www.cak.go.ke. Competition Authority of Kenya, creating efficient markets for consumers. Competitive markets lead to improvement in quality, innovation, and better prices, resulting in great value for consumers. To enhance competitive markets, the Competition Authority of Kenya is mandated under the Competition Act to regulate mergers and acquisitions. Once businesses have identified a party or parties they wish to merge with, whether in whole or part, they have to file an application with us, the Competition Authority of Kenya. We have made the notification process wholly paperless, so you can conveniently file from anywhere in the world and at any time. To start the process, simply log into our e-filing portal, click register and provide your credentials as directed by the platform. Once registered, log on to the portal and click on the menu button and select Mergers on the resultant selection panel. Type in the title of the proposed merger and click Save. The portal will auto-generate a special filing number, which will be promptly sent to the email address you provided when registering. This unique number will be used for any subsequent filing regarding the proposed merger. Once all parties to the merger or acquisition have the filing number, you are ready to fill in the merger notification form. To open the merger notification form, click on the plus sign under the merger party filings. The instructions in the form will enable you ascertain the nature of the transaction being filed. The merger notification form has 4 schedules. Schedule 1 contains the mandatory information required for any filing. Where a mandatory field is not applicable to you, a filing party, kindly indicate not applicable. The attachments accompanying this schedule are mandatory. Where a mandatory attachment is not available for your filing, attach a detailed letter and an affidavit where necessary, detailing the reasons for the absence. This may, for instance, refer to a scenario where audited financials are unavailable. Schedule 2 of the merger notification form details the products and services supplied by each of the filing parties, while Schedule 3 covers the horizontal and vertical relationships of the merging parties. Finally, Schedule 4 is a mandatory declaration form which all parties must download, fill, scan, and attach. At any stage of the filing, you may save your work and pick up the process later. Clicking the Submit button, however, indicates that you have verified your submissions. You will not be afforded a chance to edit the same. Upon submission, the portal auto-generates a PDF version of the submitted information with a timestamp, indicating the time and date the merger notification was submitted. Users can click to download this PDF for their custody and reference. The same PDF is also emailed to the registered email addresses. The portal also enables you to track the progress of your notification from the homepage. Top tip from your man Billy. Ensure all submitted documents are in English, clearly legible, and are in PDF format. For this and other tips on how to file for a merger or acquisition, visit our website www.cak.go.ke. Once your merger notification form has been received, the authority conducts an in-depth analysis of the impact of the proposed merger or acquisition on competition and public interest concerns and issues a determination. The authority can approve the application unconditionally with conditions or reject it. The authority is also empowered to impose penalties and/or initiate criminal proceedings against parties who implement mergers without approval. If you're still unsure about the process of notification of a proposed merger, you can, for free, seek an advisory opinion from the authority. Competition Authority of Kenya, creating efficient markets for consumers. Free and fair markets are key to economic growth and sustainability. The Competition Authority of Kenya is charged with the responsibility of promoting and protecting effective competition in the Kenyan market and preventing misleading market conduct. Our main objective is to enhance the welfare of Kenyans through ensuring that businesses operate in open and competitive markets, which guarantees access to innovative and quality goods and services that are competitively priced. Under the Competition Act No. 12 of 2010, restrictive trade practices are prohibited because they prevent, distort, or lessen competition in trade. Examples of anti-competitive practices include price fixing, bid rigging, customer and market allocation, abuse of dominance, and maintenance of minimum retail prices. These anti-competitive practices may involve businesses at the same level in the supply chain. This is referred to as horizontal relationship. Additionally, businesses in a vertical relationship, for example, a manufacturer and a distributor, may also engage in practices prohibited by the Competition Act, such as exclusive market allocation. Parties found culpable of infringing the competition law may, following a criminal prosecution, be imprisoned for a term not exceeding 5 years, a maximum fine of 10 million Kenya shillings, or both. The authority may also administratively impose a penalty of up to 10% of the undertaking's preceding year's turnover. Are you aware of businesses engaging in restrictive trade practices? You can report them to the Competition Authority through the e-filing portal. Simply log into the portal, click register and provide your credentials as directed by the platform. Upon registering, log in and on the dashboard, select File a Complaint and pick Restrictive Trade Practices Complaint option from the resultant drop-down menu. Proceed to populate the online form, including filling the details of the person or undertaking making the complaint and details of the accused party. Kindly remember to title the complaint. We have also provided an allocation for you to attach documentary information relevant to the complaint. You may upload as many documents as you wish. Ensure that you have reviewed all the documents for accuracy and that they are all in PDF format. Once satisfied that you have provided all the information, you can click the Submit button. Upon submission, the portal auto-generates a response confirming receipt of the application by the authority. The portal also enables you to track the progress of your complaint from the homepage. Top tip from your man Billy. The authority has in place an informant reward scheme which offers financial rewards to persons who furnish the authority with credible information, resulting in penalization of firms engaging in anti-competitive conduct. Prospective informants can contact the authority by emailing informant@cak.go.ke. For more information regarding restrictive trade practices and the Informant Reward Scheme, kindly visit our website www.cak.go.ke. Competition Authority of Kenya, creating efficient markets for consumers. Picture a scenario with two business entities, one which buys and sells goods to final consumers, and the other, the supplier of the goods. The situation could also involve buying and selling of a service. In some instances, the buyer may have such a significantly superior bargaining position that they are able to control the nature of the commercial relationship between the two. Having buyer power or a superior bargaining position is not an offense. However, abusing that power by engaging in practices such as delaying payments, unilateral termination, or threats of termination of contract without notice, refusing to receive goods despite having ordered them, and transfer of costs and risks to suppliers is prohibited by the Competition Act. So, if you're a supplier facing abuse of buyer power, or a concerned citizen who is aware of such practices in the Kenyan economy, there is a way out. You can now conveniently and efficiently lodge an abuse of buyer power complaint or submit information on abuse of buyer power for investigation by the authority. The service is offered free of charge. To start the process, simply log into our e-filing portal, click register, and provide your credentials. Upon registering, log in and on the dashboard, select File a Complaint and select the Abuse of Buyer Power option from the drop-down menu. You will then be required to provide the name of the accused party and the nature of your complaint and the complaint's details. Kindly be as clear and precise as possible in your account. Attach your supporting documents by clicking on the Browse tab and choosing the relevant supporting documents. Before clicking Submit, ensure that the information and attachments are verified and in order. Be careful to only upload the attachments in PDF or JPEG formats. Upon submission, the portal will auto-generate a response confirming that the authority is in receipt of your complaint. You can track the progress of your complaints from the portal's homepage under My Cases. Remember, parties found culpable of infringing the competition law may, following a criminal prosecution, be imprisoned for a term not exceeding 5 years, a maximum fine of 10 million Kenya shillings, or both. The authority may also administratively impose a penalty of up to 10% of the undertaking's preceding year's turnover. Another top tip from your man Billy. As a buyer or seller, always insist on signing and retaining written agreements and contracts which clearly outline the terms of trade. To learn more about the authority's mandate of sanctioning abuse of buyer power, kindly visit our website www.cak.go.ke. If you require further clarification, you can also seek an advisory opinion from the authority. We offer this service free of charge. Competition Authority of Kenya, creating efficient markets for consumers. Hi, my name is Billy and I'm here to talk to you about the Competition Authority of Kenya, CAK. The Competition Authority of Kenya is a statutory agency established under the Competition Act No. 12 of 2010. The authority's mandate is to enforce the Competition Act with the objective of enhancing the welfare of Kenyans by promoting and regulating effective competition in markets and preventing misleading market conduct. Our core mandate is to control mergers and acquisitions, protect consumers from unfair and misleading market conduct, and sanction anti-competitive practices and abuse of buyer power. Additionally, the authority advises the government on matters relating to competition and consumer welfare. In order to enhance its efficiency, and in line with the government's agenda of increasing the use of digital platforms in service delivery, the authority on September 1st, 2020 ceased receiving physical applications relating to its technical processes. All applications must be lodged through the authority's e-filing portal, which is accessible via the link that is on your screen now. To enable our stakeholders efficiently use the e-filing portal, the authority has developed and uploaded user manuals, which can be accessed on our website www.cak.go.ke. Alternatively, you can access the tutorials on our YouTube page by searching for Competition Authority of Kenya on the platform. Any stakeholder facing challenges accessing or operating the e-filing portal can channel their feedback to the authority through the dedicated email e-filing@cak.go.ke. The authority can also be contacted via our number +254 20 9000. Competition Authority of Kenya, creating efficient markets for consumers. The Competition Authority of Kenya now offers an easier and legal way to address disputes where your rights as a consumer have been infringed by a supplier of goods or services. Our complaints handling mechanism doesn't involve long queues, shouting matches, or cumbersome paperwork. And to top it all off, this service is available absolutely free of charge. Yes, you can now file consumer complaints regarding, among others, misleading representations, unconscionable and unfair conduct, and the sale of unsuitable or defective goods to the Competition Authority of Kenya through our e-filing portal. Do you have all the evidentiary information relating to the contentious transaction, such as warranties, receipts, and contracts? Have you sought redress or assistance from the seller or service provider in question with no positive outcome? If the answers to these questions are yes, start the online process of filing a consumer complaint by creating an account on our e-filing portal. Upon registering, log in and on the dashboard, select File a Complaint, then pick the Consumer Complaint option from the resultant drop-down menu. You will then be required to provide the name of the accused party and a narrative of the complaint under the complaint details. Kindly be as clear and precise as possible in your account. Attach your supporting documents by clicking on Browse and choosing the relevant supporting documents, which may include receipts, contracts, warranties, and invoices. Upon submission, the portal auto-generates a response confirming that the authority is in receipt of your complaint. You can track the progress of your complaint from the portal's homepage. Billy's top tip regarding consumer complaints: always retain your receipts, warranties, contracts, and other forms of proof of purchase. To learn more about our consumer protection mandate, visit our website www.cak.go.ke. Competition Authority of Kenya, creating efficient markets for consumers. Agreements, decisions or practices between competitors that seek to fix prices, limit output, share markets, customers or sources of supply, and other cartel behavior, such as bid rigging, are regarded as harmful to competition. Such conducts threaten the foundations of free market economies and are therefore punishable under the Competition Act of Kenya. However, there are instances where agreements or collaborative practices between competitors can prove beneficial or obtain benefit for the public. In such instances, the Competition Authority of Kenya is empowered by the Competition Act to grant exemptions that allow such agreements so long as they: 1. Maintain or promote exports. 2. Improve or prevent a decline in the production and distribution of goods and services. 3. Promote technical or economic progress or stability in an industry. And 4. Obtain a benefit for the public which outweighs the lessening of competition that the practice occasions. Further, the authority may, upon application, grant an exemption in relation to any agreement or practices concerning the exercise of intellectual property rights and professional association agreements as provided for under Sections 28 and 29 of the Competition Act, respectively. If as a business you believe that particular collaborations or agreements will result in greater public good when compared to the negative impact on competition, you can make an exemption application through our e-filing portal. Start by creating an account on the portal. Click on Register and enter the respective details as directed by the platform. Once registered, log on to the system and click on the menu button followed by Exemption Application on the selection panel. The form has instructions on what should be filled based on the nature of the information needed. You should read these instructions before proceeding to apply for an exemption. Ensure all fields in the exemption application form are populated, that is, none should be left blank. Also, Ensure that the information and attachments intended to be submitted to the authority is verified and is in order. Download the Declaration Schedule Exemption Application Form provided as a hyperlink on the exemption application form, fill it and upload it in PDF format. Any other relevant attachments, including but not limited to agreement subject to the exemption application and the confidentiality claim form, should be attached once they have been filled in. After verifying that all required fields have been filled and all attachments are in order, click Submit. Upon submission, the portal will auto-generate a response confirming receipt of the application by the authority. The portal will also enable you to track the progress of the case from the homepage on login. Remember, parties found culpable of infringing the competition law may, following a criminal prosecution, be imprisoned for a term not exceeding 5 years, a maximum fine of 10 million shillings, or both. The authority may also administratively impose a penalty of up to 10% of the undertaking's preceding year's turnover. Finally, a top tip from your man Billy. Where businesses are unsure whether an agreement is likely to negatively affect competition, they should seek an advisory opinion from the authority. Advisory opinions are offered free of charge. For this and other top tips on what is applicable for an exemption application, visit www.cak.go.ke. Competition Authority of Kenya, creating efficient markets for consumers. Competitive markets lead to improvement in quality, innovation, and better prices, resulting in great value for consumers. To enhance competitive markets, the Competition Authority of Kenya is mandated under the Competition Act to regulate mergers and acquisitions. Once businesses have identified a party or parties they wish to merge with, whether in whole or part, they have to file an application with us, the Competition Authority of Kenya. We have made the notification process wholly paperless, so you can conveniently file from anywhere in the world and at any time. To start the process, simply log into our e-filing portal, click Register and provide your credentials as directed by the platform. Once registered, log on to the portal and click on the menu button and select Mergers on the resultant selection panel. Type in the title of the proposed merger and click Save. The portal will auto-generate a special filing number, which will be promptly sent to the email address you provided when registering. This unique number will be used for any subsequent filing regarding the proposed merger. Once all parties to the merger or acquisition have the filing number, you are ready to fill in the merger notification form. To open the merger notification form, click on the plus sign under the merger party filings. The instructions in the form will enable you ascertain the nature of the transaction being filed. The merger notification form has 4 schedules. Schedule 1 contains the mandatory information required for any filing. Where a mandatory field is not applicable to you, a filing party, kindly indicate not applicable. The attachments accompanying this schedule are mandatory. Where a mandatory attachment is not available for your filing, attach a detailed letter and an affidavit where necessary, detailing the reasons for their absence. This may, for instance, refer to a scenario where audited financials are unavailable. Schedule 2 of the merger notification form details the products and services supplied by each of the filing parties, while Schedule 3 covers the horizontal and vertical relationships of the merging parties. Finally, Schedule 4 is a mandatory declaration form which all parties must download, fill, scan, and attach. At any stage of the filing, you may save your work and pick up the process later. Clicking the Submit button, however, indicates that you have verified your submissions. You will not be afforded a chance to edit the same. Upon submission, the portal auto-generates a PDF version of the submitted information with a timestamp, indicating the time and date the merger notification was submitted. Users can click to download this PDF for their custody and reference. The same PDF is also emailed to the registered email addresses. The portal also enables you to track the progress of your notification from the homepage. Top tip from your man Billy. Ensure all submitted documents are in English, clearly legible, and are in PDF format. For this and other tips on how to file for a merger or acquisition, visit our website www.cak.go.ke. Once your merger notification form has been received, the authority conducts an in-depth analysis of the impact of the proposed merger or acquisition on competition and public interest concerns and issues a determination. The authority can approve the application unconditionally with conditions or reject it. The authority is also empowered to impose penalties and/or initiate criminal proceedings against parties who implement mergers without approval. If you're still unsure about the process of notification of a proposed merger, you can, for free, seek an advisory opinion from the authority. Competition Authority of Kenya, creating efficient markets for consumers. Free and fair markets are key to economic growth and sustainability. The Competition Authority of Kenya is charged with the responsibility of promoting and protecting effective competition in the Kenyan market and preventing misleading market conduct. Our main objective is to enhance the welfare of Kenyans through ensuring that businesses operate in open and competitive markets, which guarantees access to innovative and quality goods and services that are competitively priced. Under the Competition Act No. 12 of 2010, restrictive trade practices are prohibited because they prevent, distort, or lessen competition in trade. Examples of anti-competitive practices include price fixing, bid rigging, customer and market allocation, abuse of dominance, and maintenance of minimum retail prices. These anti-competitive practices may involve businesses at the same level in the supply chain. This is referred to as horizontal relationship. Additionally, businesses in a vertical relationship, for example, a manufacturer and a distributor, may also engage in practices prohibited by the Competition Act, such as exclusive market allocation. Parties found culpable of infringing the competition law may, following a criminal prosecution, be imprisoned for a term not exceeding 5 years, a maximum fine of 10 million Kenya shillings, or both. The authority may also administratively impose a penalty of up to 10% of the undertaking's preceding year's turnover. Are you aware of businesses engaging in restrictive trade practices? You can report them to the Competition Authority through the e-filing portal. Simply log into the portal, click register and provide your credentials as directed by the platform. Upon registering, log in and on the dashboard, select File a Complaint and pick Restrictive Trade Practices Complaint option from the resultant drop-down menu. Proceed to populate the online form, including filling the details of the person or undertaking making the complaint and details of the accused party. Kindly remember to title the complaint. We have also provided an allocation for you to attach documentary information relevant.
Good afternoon, everyone. I believe you enjoyed your lunch. Am I right? Okay. Welcome back to this session. And I'd like to start us off. We are running short of time. So allow me to welcome on stage Mr. Isaac Tausha from the COMESA Competition and Consumer Commission, and is going to take us through a brief, I'd call it a fireside chat, on competition law and consumer protection, focusing on opportunities for integrated enforcement. So let's give our attention to him. We can give him a round of applause as he comes on stage.
Okay. Good afternoon. Good afternoon. Okay, you know the beauty of presenting in the afternoon is that you will not get too much attention, and as such you can just present in a way you would prefer. But just taking care of time, by show of hands, I just want to have an appreciation of who is here and is from where. So those from law firms, Okay. Those representing the private sector? So where are you from? Where where are you people from? Okay. Oh, okay. Okay. From competition authorities? Ah, okay. Academic? Okay. And those who offer advisory services to companies, probably? No, okay, that's fine. So I'm going to be talking about the Commercial Competition and Consumer Commission. And actually, the presentation will focus more on the new regulations that have just been promulgated. And it will just show the few salient features that could be of interest to business, to the academic, to those who offer advice to different companies. And in particular, we'll highlight more on what's there in COMESA as a region, not necessarily from the Commercial Competition Commission, but what are the opportunities? And also, in the presentation, I will talk about Commercial Competition Commission's relationship with national competent authorities, and as well as with other regional economic groupings, as well as continental ones. So that's us. So my presentation will just focus on what COMESA is and why it is important to appreciate the operations of COMESA and the significance of having a regional competition authority and what the business, particularly in Kenya, should know. I was advised that there will be a lot of people coming from the private sector. So you will see that the presentation will point more to say what then should the private sector do to abide and probably also to take advantage of the existing platform. And then, like I said, you then focus more on the new regulations, what's the salient features in terms of enforcement, in terms of measures, and then in terms of consumer protection, so that when we go out there back to our offices, either from the private sector, we'll then be advising our businesses or our leaders in the best way possible. If we are coming from competition authorities, we know our obligations insofar as regional competition issues are concerned. And if we are coming from the academia, we also see how best we can make use of the regional authority to the best of our objectives. So this is what COMESA is. COMESA is made of 21 member states from Southern Africa, East Africa, and then North Africa. And Kenya is quite a big player in there as well. And it has a population of around 640 million people, 12 million in terms of land area. And I can tell you that through the work we've been doing as a competition authority, we realized that COMESA as a region is a net importer of quite a number of agricultural commodities, despite having this vast amount of land available for cropping and or animal production, which is a conundrum. We need to find a solution. And ourselves importing grains from as far as Russia, and we be affected by the conflicts happening up there. We have a GDP of 1 trillion, and in terms of exports and imports, around 383 billion. Intra-COMESA trade is around 10 billion. And like I said, you find that also there is very minimal intra-COMESA trade, which is something that we need to talk about through this presentation, so that the businesses around here, the advisors thereof, and all the academia people here can equally have interest in researching and understanding why and how best can we ensure that our industry takes advantage of the existing opportunities and also the existence of the regional competition authority to ensure that there is more investment and more trade among the COMESA member states themselves. So it's something for us to look at. And in terms of history, COMESA started as far back as the 1980s as PTA and then became COMESA in 1994, and that's the COMESA we have today. So what was the drive besides having, behind having COMESA? It was mainly to enhance trade amongst the member states. And then in that process, there will be, it was envisaged that there will be economic growth. So the integration was coming in the form of liberalization, which is a reduction of trade tariff barriers, okay? They are coming back in some regions, but it's something that COMESA was meant to be. We open up our markets for each other so that there could be more trade. And through that trade, it creates opportunities for employment. And actually, it also creates an environment that is suitable for investment. And through cross-border trade, all the economies were bound to benefit and grow. So at macro level, it was anticipated that there will be economic growth, there will be more investment, there will be more exports. And for the businesses, this is what you have to see in COMESA. I told you close to 640 million people. That's a big market for businesses. For those who are looking for opportunities, COMESA is available as a market that you can exploit. And equally, it can be a source of raw materials for some of the products we produce. In as much as we all produce almost similar primary products, but there are some semblance of manufacturing that is happening and which we need to make use of and take advantage of the opened borders so that we can make more profits. We can together also attract more investment and create more employment for ourselves. And at micro level, you know, whenever markets are open to imports, there is expectation that the market will have a variety of goods. It is expected that there will be competition in the markets, and then we have the efficiencies associated with that. And equally, there will be much more greater choice for the consumers. So in terms of welfare, it is expected that once you have the employment, and then you have a variety of commodities to choose from, and they are lowly priced and high quality, your welfare is expected to go much higher. So what is the problem? The problem is, in as much as economies are opening up, there could be non-tariff barriers. If you listen to what I was saying, I said the liberalization was mainly envisaged and mainly targeted at tariffs, but there could be also non-tariff barriers that can still affect trade. Some of them can be in the form of sanitary and phytosanitary requirements, and then there is the big one which COMESA Competition and Consumer Commission focuses on, which is firm conduct, firm behavior, to the extent that companies can agree to share markets among themselves, and the sharing of markets can be to the extent of sharing countries, where they will agree, say, you operate in Kenya, I operate in Tanzania, or maybe let me use COMESA member states. You operate in Kenya, I operate in Malawi, or Zambia, or Uganda. So you see, in those markets, once shared, it means those companies will be monopolies in there, and thereof the effects of having monopolies, we all know what it is. And there is also a possibility of companies having vertical agreements, which may lead to vertical restraints, and which can be in the form of territorial restrictions on passive sales, which then affect trade amongst the member states. So that realization by our four bearers who started off this COMESA business, they realized that there was need then to have regulation to guard against such kind of behaviors. And that's how COMESA, Competition and Consumer Commission was promulgated. And then you find in the COMESA Treaty, Article 55, it is very clear and it shows and explains that any anti-competitive agreement should be prohibited. And you go down through the treaty, it also talks about the promulgation of regulations to manage or to ensure that there is no such kind of behavior in the common market. So that's how the COMESA competition and consumer protection regulations came to be. They follow on Article 55 of the COMESA Treaty. So I don't want to take much into your time, but these are the benefits to the Kenyan business. So if you are from the academic, you are from the advisory side of business, you are from the business itself, you need to take advantage of this very huge market called COMESA. I told you already, 21 member states, it's a big market. And you know, ironically, you find that our majority of our companies, they strive to export as far as Europe, but they don't want to export to the very closest of our neighbors. But we know, of course, there could be other challenges beyond competition which can cause that. But as I stand before you today, I just saying, please, if by any chance you have an opportunity to really look at opportunities, look into the COMESA market. Because you will have access to that big market, you have access to very big source of raw materials, and there are no tariff barriers as it were. And if you do have or meet any such, then the COMESA Competition and Consumer Commission is available to assist you. So what should the business know? You have to ensure that in as much as you operate in this and or have identified these benefits and or opportunities, then you should guard against the practices I've talked about, calling them non-tariff barriers like collusion, like abuse of dominance, vertical restraints. We'll go into detail as we look at the new provisions of the regulations. So the reality is, colleagues, globalization is with us. And equally, you find markets are very much so regional. The majority of markets now, they go beyond our borders. And I think the very clear example is there for everyone to see. What happened during COVID-19, it told us that we are not self-sufficient in terms of agricultural commodities. What happened in Russia and Ukraine caused the global rise in prices, inflationary pressures, which then ended up affecting us here down in Southern Africa, East Africa, or Northern Africa. Worse still, before we even forgot about 2019 COVID, now there is USA and Iran, which is also showing us signs that there is possibility of there being hikes of prices as well. We have already experienced hikes in fuel prices, and it shows you that markets are no longer just national. They are regional, they are global, they are continental. And as such, why should we then have a framework like what COMESA is? You know, whenever you are operating in a market and you have a regional or continental authority, what does it do? It helps you to reduce on cost of doing business, on cost of investing in that economy. And what does it mean for the business in Kenya? Now you won't need to have multiple notifications. You don't have exposure to risk of conflict of regulatory decisions, wherein you find one country approves, another one approves the conditions, some actually rejected transaction. Now, if you have a single notification at the commercial level and or at FCFTA when they become operational, you have one decision, and that is very beneficial. It also reduces administrative burden as it were. So, to the Kenyan business, like I said, the bureaucracy will not be there. You have lower compliance costs. there's predictability in the environment. But now what should you do? I think the best is for you to also aim higher. Have that view beyond Kenya, the Kenyan market. We need you in Eswatini. For your own information, at least for now, I was very happy when back home in Zimbabwe, I saw a lot of Kenyan products. I was like, yeah, this is COMESA. And I saw some Egyptian products in Rwanda as well, which is what we should aim to do, actually, and make use of this framework for our own good. So, to the new regulations, as you might be aware, and I think Vela was talking about it earlier on, to say that we do have the new COMESA competition and consumer protection regulations that were approved by Council last December. And these regulations, these new regulations, actually they have tried to improve on the existing, the 2004 regulations. And to tell you that they maintained the very basic of competition regulation provisions, obviously on enforcement, on measures, and on consumer protection, but there were some salient features that were just added to make them more robust and to bring in, and or maybe to allow our stakeholders to enjoy the benefits of what I've already talked about, access to markets, access to raw materials, access to more investment, and other benefits thereof. So you see that the new regulations are now very explicit on public interest consideration. I think if we all listen to Simon's session in the morning, you heard South Africa being touted as the first to come up with these public interest considerations, and they were being silently considered, but now they are very explicitly provided for in the new regulations. And the per se prohibitions, obviously, they're still there in terms of horizontal agreements. But of interest to you is to note that now the new regulations have also provided for per se prohibitions on vertical restraints. It's a first. But you'll need to understand why it's like that. It's because COMESA is a regional organization, like I said, and its main objective is to allow for more trade amongst the member states. So if there is a restriction on that trade, then it means that practice is totally against the tenets of having a regional economic community. So that's why you find the COMESA found it necessary to have per se prohibitions on vertical restraints, like restriction on passive sales, absolute territorial restrictions, and resale price maintenance. So as people from the business, as academia, as people from competition authorities, you need to be aware that there are those provisions in the new regulations. And as you advise your seniors or your marketing teams, you need to make them aware that there are such kind of provisions, which the Commission, the COMESA Competition and Consumer Commission, will be looking out for. And it is in the best interest of business not to be found wanting in respect of such kind. The Commission is available to offer any advice if need be, and we can easily be approached. And at the end of the presentation, there will be details on which you can find the Commission. There are provisions on gatekeepers. These ones, we have not yet applied them because there is need to come up with the guidelines which will give guidance to all the stakeholders on how they will be applied. Abuse of economic dependence, which is more related to abuse of buyer power, but it goes beyond that. These are also new provisions in the regulations which you need to be aware of. And issues around digital markets. We inherited a lot from our FCFTA competition protocol to come up with this provision, and it is basically to ensure that the Commission has powers to really reign over digital markets. You will see later on when I talk about the new thresholds that has been promulgated to cover for that. It was a reaction to the finding that there were measures that were going unnotified to the Commission because they didn't meet the monetary threshold that existed in the old regulations. The Commission also now has a lenience program, which in the unlikely event, because now we are talking about in the unlikely event that your firm or the firm you are advising is found wanting in respect of cartels, you can use it. You can make use of it, but we don't, we don't encourage you to anticipate to use it. But in the unlikely event, then you can make use of it. It's meant for you to do that. And there are also now comprehensive provisions in terms of market inquiries. One thing that I would want to make you understand is that it is under the market inquiry provisions, it is mandatory and obligatory for any company that has been approached by the Commission seeking for information to provide that information. So it's something that you need to be aware of because there are also penalties associated with not obliging with that provision. So what is the benefit? So now we are saying, like I said, the COMESA market is available for you. Now you will have access to wider markets which are protected because the Kenyan firms, when accessing these markets, you'll be protected from cartels. You'll be protected from unfair platform dominance. That will also ensure you have access to fair distribution channels. So you see the beauty about competition regulation, and in particular at regional level, is that it protects everyone. You know, sometimes firms think that competition regulation are meant for the big players, and the big players think that competition regulation overprotects the small players. But let me tell you that it is for everyone, including from the small scale, medium scale to the large scale. They all benefit from the competition regulation. So what should we do as business advisors, as business owners, or as employees? There is need, especially now I told you that they have vertical restraints which are now per se prohibited. You need to have a look at your agreements. Audit them to make sure that they do not have those vertical restraint provisions. And also you need to train your commercial teams to ensure that they avoid per se illegal conducts. And just be aware of any other prohibitions of the competition regulations. And there are digital platforms, I understand there are some from the digital markets. Yeah, if the guidelines comes out when they are being developed, you need to be aware, take part in them so that when they eventually are applied, you would have made your contribution and make sure that they align to the best practice. Like I said, you can make use of the lenient program, but it's not something that we encourage. Then, insofar as measures are concerned, the Commission changed to a suspensory regime from a non-suspensory regime. So what this means is that now you cannot consummate a transaction without prior approval of the Commission. So you need to be aware of that. There used to be a 30-day window period where you can agree and then notify the Commission within 30 days, but now it's no longer the case. Some would want to understand why is it like that. It's because it has been identified that there were problems with that system. There were a lot of negotiations back and forth just to appreciate whether firms can notify or they can hold on or they can continue to discuss. So it was found best to have a suspensory regime. So what it means is that the firms cannot initiate, cannot consummate a transaction. Now you have the leeway, negotiate whatever you want, take your time, but you cannot consummate a transaction before the approval of the Commission. There is derogation, of course, but there are risks associated with it. Because insofar as the regulations are concerned, notification is still mandatory, and sometimes the risk of unscrambling the egg is too high. This one, it ensures that there is, it ensures that there is clarity and efficiency. So when you are promulgating your major transactions, you have to look at that and take that into consideration as well. Joint ventures, they've been now clearly spelled out in the regulations, and they are used to be a hazy area in the old regulations. So now it is very, very clear. Insofar as digital markets are concerned, now digital measures notifiability is not determined on the basis of value of assets, turnover. It's no longer the case. They're now determined on the transaction value threshold. Let me hasten to mention that there will be guidelines. The Commission is in the process of developing guidelines for all these provisions in the regulations. And when those guidelines are drafted, you will all be called upon to comment on them, and that will be your opportunity to fine-tune the guidelines. And in addition, since the Commission introduced a suspensory measure regime, it has also come up with what is called an expedited measure review process. So this process is to ensure that, you know, it was thought of out of the realization that firms will always say 120 days is too long a time for us to wait. So in those transactions where there are no competition issues and there is no probability of member states requesting for referrals, such transactions can then fall under the EMR. But there are conditions to the EMR. Like I said, for you to be part of that, you notify the Commission, you indicate to say you are interested in applying through this process. The Commission does its initial analysis of your transaction and then can confirm to you that you can proceed through the EMR process. And it takes up to 45 days to approve such kind of transactions. Public interest, like I said, the Commission now has, it now considers public interest, but the core principle is that competition effects remain the primary determining factor insofar as approval of measures is concerned. So some of the factors considered: employment, SME competitiveness, regional or global competitiveness, and then sustainability and environmental consideration issues, as well as innovation. So all these are taken into consideration when the Commission is making determinations on measures, is making determinations on application for authorizations, and equally when looking at agreements as it were. So this actually can be very useful to our private sector. Whenever you are coming up with the transactions, take that into consideration. And that could be some of the factors you use to justify your transaction. And issues of sustainability, they've now been also provided for. We are moving in a world where environmental issues are a concern, and as such you find collaborations on research, collaborations on issues to ensure that we reduce environmental degradation can equally be very much considered in competition regulation. So it means from a Kenyan perspective, you can equally also, as you draft your transaction and look at those considerations, can be very, very helpful. Consumer issues. So you find the COMESA Competition and Consumer Commission, it was called COMESA Competition Commission, right? There was no consumer in between. So out of the realization of the significance of consumer protection, you find now the name contains consumer, and that is it symbolizes also the very the very provisions that have been put in the regulations to cater for consumer protection. So the new regulations recognizes all the consumer rights, and it also guards against some digital unfair trade practices like dark patterns, digital content, harmful digital content, and all those issues now have been provided for. And what we are telling the business community today is to say, when you have your platforms, digital platforms, make sure that you are not engaging in these kind of practices, dark patterns, hidden fees, misleading user experiences, and ensure that they are transparent. We were having a session just before lunch here, and it came up with very interesting issues that we might need to be aware of. And now, there's always a question around jurisdiction. Say, how do you deal with overlapping jurisdiction between Quadro C and the national competition authorities, Quadro C and other regional authorities? I know what comes to mind mainly is Quadro C and EAC. So the new regulations have made provision that try to cater for that. And for the relationship between Quadro C and the national competition authorities, it has been always provided for the obligations of the national competition. I mean, the obligations of member states have been quite clearly outlined in the regulations, to the extent that there is clarity in terms of jurisdiction. There is subsidiarity, which is very clear. Say, in any matter that goes beyond one member state, it then goes to COMESA. If anything that is confined to one member state, clearly it goes to that jurisdiction. So when we talk about what goes to COMESA in terms of measures, obviously we look at whether it affects 2 or more member states, it meets the financial thresholds if it is not a digital market measure, and to also meet the notifiability thresholds. So that is very clear. And the Commission has also signed the MOUs with the various member states, including Kenya itself. And we also work together in terms of capacity building, harmonization of the regulations, and all that. And there is continuous engagement formally and or informally. But then with the other regs, and in particular the Continental and EAC, we also in the process with EAC, Quadro C, COMESA, and EAC, we have signed an MOU to try and make sure that we work together insofar as be it measures and or investigations that cut across the 2 jurisdictions are concerned. What the aim of this is to try and limit, because we cannot eliminate really if it's for measures. Double notification, it might not be possible, but what COMESA and EAC are doing is to come up with a framework that will ensure that we minimize the possibility of double notification, so that we ensure the one-stop shop form remains, and equally we reduce the cost of doing business to the investors. And with our brothers from AFCFTA, the new regulations already recognize that there will be a continental competition authority, and as such has already made a provision which ensures that we cooperate with the regional and the continental authority. Other provisions, settlements are there, and of critical importance, the suspension of the regulations in times of crisis. We have learned from COVID that there could be times when it becomes really necessary to do that, and but these provisions will be used in very critical circumstances. But in as much as that can happen, still the national regulations can apply. Then in terms of the institutional structure of the commission, this is what it is now. It has changed a bit. We used to have the secretariat, which is the one based in Lilongwe, headed by our CEO. And we used to have what was called CID, Committee of Initial Determination. And then if any party was not happy with the decision of the CID, they would appeal to what was called an appeals board, which was made of the other component of the board, the remaining part of the board, which was not part of the CID. So it was meant to separate the committees. So now we do have the secretariat, which does the investigation, market inquiries, studies, and whatever. And then there is a panel responsible for determination. And that panel has the responsibility to make decisions, and their decisions are final. And if anyone is not happy with that decision now, the provision is that you go straight to the Commercial Court of Justice. That's the new setup. It was meant to make sure that we have a lean investigation and adjudication process. So what are we saying from Commercial, Competition and Consumer Commission? We are saying for the Kenyan businesses, the commercial framework is not just a compliance obligation. It is a strategic tool. Those who understand and integrate it into their market, investments and digital strategies will be best positioned to scale, compete, and lead in the regional economy. Thank you.
Thank you so much, Isaac. Could we just give him another round of applause? Isaac has given us a very good overview of the mandate of COMESA, its ongoing processes, and areas that we can think around for integrated enforcement. I'd like us to move to part 2 of this afternoon, where we are going to have a plenary session, and we are going to be looking at competition and consumer protection in digital financial services. So this session is going to explore the importance of competition in digital financial services in the context of rapid technological and economic change. Competitive DFS markets are essential to promoting innovation, efficiency, consumer choice, and inclusive growth. The discussion will also consider the importance of consumer protection, particularly the need to ensure transparency, fair treatment, data privacy, and effective safeguards against harmful practices in digital financial markets. Allow me to invite Mr. Rory Macmillan. We can give him a round of applause as he comes up to the stage. A brief bio about Mr. Macmillan. He's a founding partner at Macmillan Keck, attorneys and solicitors. Rory began his career in 1994 in New York and London with the international law firm of Debevoise and Plimpton, where he worked for 9 years before he established Macmillan Keck with offices in Geneva and New York. Rory advises businesses, governments, competition and regulatory authorities, regional economic community authorities, and development finance institutions on competition law and regulation in digital, telecom, and other markets. He has also led market inquiries for the CAK in banking, mobile money, telecom, and leasing. In addition, Rory has advised the COMESA on their regional merger review regimes and the former on cartel enforcement and leniency. Rory holds his LLM from the Yale Law School, where he was a Fulbright scholar, and his LLB is with a first-class honors from Edinburgh Law School. Allow me to invite the following panelists to join him on stage. We have Mr. Ahmed Damish. Welcome on stage. We can appreciate him as he comes. So Mr. Ahmed is from UNCDF as an inclusive financial policy and regulatory specialist. I'd like to also call Mr. Ryan Hawthorne from Acacia Economics. You can appreciate him as he comes on stage. Next, I'd like to invite Ms. Doreen Wanjiru. We can equally appreciate her. Ms. Doreen Wanjiru is from the ODPC office. She is an assistant data commissioner. Allow me to also welcome Mr. Boniface Kamiti. He is from the Competition Authority of Kenya, the manager in charge of consumer protection. I'd like some help in just creating space with the podium. Mr. Ruri, I hand over the session to you. Thank you.
Hello, good afternoon, everyone. Thanks so much for the introduction. It's wonderful to see everyone here. We're going to cover a wide range of topics. We want to look at competition, of course, in Kenya's digital financial services market, look at that in context of the region. Want to see what's working, what's not, what sort of barriers there are. Want to look a little more closely at digital credit, see what's happening there, particularly why are the prices so high, look at some of the practices that are still happening. Then we want to look into the data ecosystem that we have, what's working in the way data is used and what's not working, and particularly what is happening with people's personal data and how is that used and misused. We'll look then also at a little bit at regulatory fragmentation or complementarity amongst the different institutions that are involved. We have a number of them here today. And then we want to look also at the cross-border dimensions here. Now, with us here to guide us through this, we have really a superb panel, and I have the pleasure of having worked with all of them except Doreen personally. I'll start with you, Doreen Wanjiru, who is Deputy Data Commissioner, as you've just been told, at the Office of Data Protection Commission. And the ODPC, as many of you will know, has now a really extensive history of enforcement of the Data Protection Act in Kenya. And this is playing into how data is used in the digital financial services markets. And so looking forward to Doreen's contribution there. We have, to my left here, Boniface Kamati, who's Manager of Consumer Protection at the CAK. We first worked together 10 years ago when Boniface was leading enforcement actions and pursuing digital financial service providers, getting their screenshots of what consumers were being told about the services that they were having, and then hauling them in and sitting them down and saying, hey, you guys are not doing everything the way you should be. So Boniface has been in this for quite some time. We've both added a few gray hairs since we first started working together. Ahmed, further to my left, Dermish from UNCDF is one of the, I think, best systems type thinkers that I've come across in this field. He's the specialist in financial inclusion. He's based here in Nairobi, working in East Africa, but actually globally as well. Moved here from Brussels, and so you have really on their doorstep here a veteran now of this field. He was telling me over lunch how actually they wrote the supervisory guidelines after M-Pesa was first launched, after that no objection letter that many of you will remember. And then to his left, Ryan Hawthorne, who we've also worked together for over 10 years. In fact, our first time working together was for the CAK on market inquiry, where we were looking at the mobile money market and the prices that Safaricom was charging other players for accessing USSD channels, which were more important then than today, but they're still relevant. And as a result of that inquiry, their USSD pricing, which was so high it was excluding other players from the market, was reduced by 90% overnight, effectively, as a result of that work. So Ryan is really one of the leading economists on this continent, and has done a lot of magic. So we're going to do this as a sort of a retrospective. It's 2036. Adjust your watches, your calendars. The world is turning out better than expected. Everyone is a little negative in 2026. Things were going downhill, but it's 2036. Things are good, especially in the digital financial services sector. It's grown, flourished since 2026. Consumers are making informed choices of products that meet their needs for a whole variety of providers they're able to get those from. There's been transformative innovations in payments, savings, credit. Financial inclusion has deepened significantly. Prices are reasonable. Digital credit defaults are now within international norms. In fact, digital credit is finding its way into embedded finance. That's further enabling the SMEs, families to invest, grow. Predatory lending is down, checked by enforcement. In the East African region, payment system interoperability is enabling growth. Increasingly integrated regional financial services market that is easing movement of capital, goods, trade. So things are really good in 2036. The question is, we've been asked by the central bank, who's not on this panel, you'll note, to look back over these 10 years and figure out what worked so well, what interventions were so successful that got us to this wonderful point in 2036. So I want to just start by asking each of the panel just to give their immediate thoughts on what in those 10 years made a huge difference. And then we're going to start digging more deeply into the sorts of issues that I mentioned there. And I'll start with Ahmed, if you could offer your thoughts on that, please. Thanks.
That's better. Thank you, Rory. It's a pleasure to be here. And thanks for framing the question creatively. So we are 10 years in the future, and we are now looking back, if I understand the question right, and reflecting on what's worked. Maybe a way to frame it might be, what were the issues as we look at them in retrospect, particularly in the case of Kenya, but also thinking, more broadly, this idea of digital financial services, modernizing the financial sector, leapfrogging. These are things that we were doing in 2026. I have to fix my language. We were doing in 2026 for about 20 years. So really, we have to think back to what were our expectations in 2006, when the letter of no objection was still a sparkle in the eye of the CBK. And I think in 2026, I think the concern is we're plateauing. We're seeing extraordinary access to financial services. The idea of the mobile revolution has come and gone. Now we're gone beyond that. And so people have devices, but we're not seeing the depth of services that we thought we would see in 2026. And so I think the question at the time, context and independence, and if we think about resilience at the national level, how are our financial sectors secure in a way where we can be a little bit more insulated from what's happening all around us? And our capacity to create innovation domestically was built on not only an enabling environment, but having sufficient infrastructure, having sufficient depth to sort of grow. And so I think in real terms, what I hope we learned, as I try and frame this memento-like play we're playing here, was, we invested in infrastructure, we invested in interoperability, we really thought about depth of services, not just breadth of services, thinking about things like insurance, thinking about things like savings, thinking about things like investment, but that was really integrated with this idea of leading again. And if I had to say the one thing we did in 2026 that got us to a great place in 2036 is we leapfrogged again. Not only doing it once, like was done in 2009, where we were a world leader in digital financial services, but we managed to do it again, harnessing this investment in infrastructure and connectivity, et cetera.
Thank you, Ahmed. Let me pass to Ryan. What were the issues in 2026? And as Ahmed said, what enabled us to leapfrog to where we are in this wonderful 2036?
Great. Okay. Well, we've just started looking at this in. Hello. Thanks. Okay. Great. So. I think where it would be great to be in 2036 is a market in which prices are a lot more competitive. I say that not only in respect of in respect of lending, but also in respect of just mobile money prices. So we've just started looking at this now, and we're doing sort of a broad competition piece of work on in markets for digital financial services. And the biggest problem in African countries, and it's the same in Kenya, is that what we have is these awesome mobile network operators that offer digital financial services, mobile money, but at really very high prices. I say most, many African countries, but it's, there's some where it's free. So across the border in Somalia, of course, where Rory and I have done some work, mobile money is free. It's free to send and receive money. And so, to me, the question in 2036 will be: is what would help us to get there, to that point? And a range of interventions have been implemented all around the world. So, and we're starting to look at this now in Kenya, of course, much more and deeper interoperability. The central bank is looking at defining how interoperability is going to work: a fast payment switch, an instant payment switch. Of course, some open data proposals are on the table, and it's being investigated at the moment. And of course, we think with all of this, hopefully, prices will come down. So I would say prices is an important one.
Thank you. So we'll come back to interoperability, open data, and so on. Doreen, what magical changes happened between 2026 and 2036 that you'd like to think about?
Thank you. I'm happy to join this conversation. I think the magical thing that happened from a regulator perspective is that the regulators collaborated. They came up with a framework that works. They spoke to each other and reduced the compliance burden that was on the financial service providers. Not only did they collaborate with each other, they collaborated with the sector. So they allowed the sector to, and also encouraged the sector to have self-regulation. So where the sector came together and found the best practices that they can put in place in order to have compliance. The sector, not only the giants, but also supported the smaller players that were coming in and allowed them to have a good example of what regulation would look like. In addition, enforcement worked, where not only did enforcement were decisions given, but there was execution of those decisions, which is a big issue specifically in this country, because say we do not have the capacity to be able to see enforcement through, especially against big giants. So enforcement worked, guidance worked from the regulator, because you're telling the sector, this is what we want to see from you, and this is how we want to see it from you. So that worked, and this is 2036, and things are working.
Thank you. Do we have a microphone we can get to Boniface? Boniface, please.
Yeah, I'll just pick up to what my colleagues have said, Ahmed, and also Doreen, in regards to the issues that were there in 2026 and just a few years before that, and what has happened with regulation and regulators is that in 2026 and just a few years before that, it was a wild market. It was a Wild West, as they say it. And there was multiple borrowing. Yes, financial inclusion increased, but there was a lot of multiple borrowing. Consumers still could not understand some terms and conditions. There was still issues with fees and charges. There were aspects of aggressive debt collection practices, and quite a number of issues in the digital financial services. But from the regulator perspective, there was the realization that we are now a global village, not just nationally, but also regionally and internationally. Nationally, regulators are speaking to one another, not just the competition regulator, but also the communications regulator and the regulator for data protection and the financial sector, regulators across banking, insurance, retirement benefits are now speaking to one another. Regionally, the regulators are, collaborating at the regional level with the RECs. And internationally, because you've seen transactions happening across the board in terms of transfers, payments, and you just mentioned interoperability, then we have seen that there was the need to collaborate internationally. So, and that's why 2036 is a bliss, as you would say.
Well, that's really great. We've got, I think, this vision of deepening of the sector that Ahmed brought, and deepening into insurance and savings and better credit. We've got Ryan's point about pricing, which seems pretty key, really, right? I mean, how can you really grow the sector across the board if prices are being held up? There's collaboration amongst regulators. The Doreen, you brought up greater enforcement guidelines, and then you echoed, I think, all those points, Boniface. So let's begin to look at competition in particular, starting there, looking at the state of the market and what was needing to happen in 2026. Where had it reached? Where had it not yet really become competitive, and that was going to help? What were the issues in competition in particular? Maybe we start with you, Ahmed, and then Ryan, you might have some thoughts about that.
Yeah, absolutely. Sitting on this panel with you guys talking about competition means I'll make my answer brief. Oops, I'll get that in a second. So I think in 2026, it was not one issue per se, but I think the vision for building the financial sector here, where choices were made regarding competition, and this was a very common one we found globally, particularly when we wanted to disaggregate and unbundle the dependency on banks and other financial institutions, and mobile operators came in who owned the pipe and the service, and it was seen as innovation in those late 2000s, early 2010s, have now gotten us to a point where we had a degree of dominance defined and expressed in different ways, not just in Kenya, but across many African and Asian markets that were reliant on the mobile channel in particular. And so what we had in the competition context was not a singular issue. These entities are now allowed to provide X activity to the exclusion of others, but rather several decisions that were not integrated. Independently investment in interoperable infrastructure, independently addressing exclusivity, independently thinking about innovation and fintech, independently trying to deal with digital credit, independently trying to address fair access to infrastructure. All of these were the right things to do because they were dealing with issues as they arose, which is the implication of innovation. But I think reflecting back on 2026 in the competition context, where things changed is when, from a capital P policy perspective, we started to think about an integrated solution. How does better prices, and fair access to infrastructure affect the quality of service that's expected and affected? How does that reflect in the use of digital credit in a way that's more productive and less detrimental? How does our enforcement capacity, when integrated with good coordination, reduce the inappropriate approach that some providers used in 2026? So it was really sort of drawing together a lot of well-intentioned policies into a more coherent one that made ex ante sort of a solution to competition so we wouldn't have to deal with the problem later on. That's my best answer.
Thank you. Ryan, particularly, where are the bottlenecks? Where are the barriers that are holding back, for example, pricing that may be causing friction in innovation and growth in the sector? And we'll come back to how we might deal with them, but maybe start with that.
Sure. So, I mean, as Ahmed was just saying, the problem in a lot of sub-Saharan African markets is we have these mobile network operators that have control access to the infrastructure over which mobile money services are provided, of course, but then also they control a lot of the data that they've collected over many, many years. But not only that, is a big difference between markets in Africa and in Latin America, certainly, and of course in developed countries, is that because they're these, we don't, the banking system doesn't reach as many people. The service that's really reaching the mass market, most consumers, is the mobile networks, and those mobile networks are far more concentrated. There's maybe one, maybe two, maybe three big players in most markets. That's a very different setup to normal banking markets in Latin America and in developed countries. So the example that we love to look at is Brazil, where you have this wonderful fragmented market that happened deliberately, as Ahmed was saying. There was a deliberate choice by the central bank governor to break things open back in 2013, following the 2008 financial crisis. And boy, that is what he did. And now we have this highly fragmented, highly competitive market in which there are many providers offering many services. Now contrast that to the situation in our economies, where we have a couple of big mobile network operators. That's it. That's a much harder. That's a much harder market problem to tackle. Market concentration problem to tackle. So I would say the bottleneck really is there in our markets. It's our mobile network operators that we need to think carefully about. And, yep, so that's all.
Let's pick up on that. Just hold on to the microphone, Ryan, because, we have interoperability, don't we, between wallets here. We have interoperability between bank accounts and wallets. We have multiple digital credit service providers. We've, so can you drill in a little bit to what's holding that back?
Great question. So we have interoperability here in Kenya, right? You can send money from your bank account to your M-Pesa wallet very easily, and vice versa. But how would you compare and contrast that to making a simple M-Pesa to M-Pesa transfer? If compared to transferring money from your mobile wallets into a bank account, how would you compare the user experience? Dramatically different, right? What are the fees involved with that? Is that free? Is it? And what is being charged when you're sending money from a bank account to a mobile wallet and vice versa? So interoperability has some critical dimensions and features that we think play a very important role in explaining how the competition effects play out in the markets. If you don't have a seamless user experience, and we see this isn't a problem in Kenya, by the way. I know everybody loves to see Kenya as special, and you are special, okay? Kenya's special. But we see this in a lot of mobile money first markets, okay? Where we're sending a mobile money transfer where there's an interoperable fast payment switch. It's working, it's instant, etc. But you're sending it from MTN to MTN in Ghana, for instance. You just type in the person's number, off you go. If you want to send it from MTN to, I think it is, I can't remember what the other big operators in Ghana now, Orange maybe. You know, you have to firstly say, okay, you'd like to send it off net, sure. Then we'll take you to the next menu. Okay, which network operator is your sending party, you know, on? What network are they on? I don't know what network, you know, most of my friends and family are on. I don't know. You know, and then you have to enter the number, of course, and then there's a check, and all of this takes additional time. So interoperability, there are layers of interoperability that we think need to be carefully thought about, and of course, pricing is critical.
So we're in 2036, and we solved this, right? So how, maybe, Ahmed, do you have a thought on, how did we solve this one, given its importance? Or, well, if you have a thought, or Ryan, further thought, or?
Sure. Okay, so the way that it works in highly successful markets, again, Brazil, and I'm sorry, I'm a little bit obsessed with Brazil. Have a look into Brazil. Okay, it's great. But they have a very nice alias translation service, okay, for Pix in Brazil. It's their fast payment service. You can have 5 or 6 different ways of telling somebody how to send money to me. In other words, you can call me my name, you can give me a number, there are whole different ways of identifying me. That address translation is instant, and it is universal, including for on-us transactions. So if I transfer money from my new bank account in Brazil to a merchant that's on Nubank, it all goes through the same address translation service in Pix, and the user experience is uniform, completely uniform. It is also, wait for it, free to the consumer. So they do allow merchant charges, and we are debating, you know, to what extent, you know, should one regulate user charges or not regulate user charges? That's a very difficult debate. Turns out, so far at least, this is initial stages of our research, it doesn't really matter. You don't necessarily have to regulate the user charges. As we know, in Kenya and Ghana and all of our various mobile money first markets, the user charges are really high. People use the service. So the regulation of the price, you know, we're not very convinced about, but prices will be very, very low because anybody will be able to offer a fintech, a mobile money service that will be instantly interoperable for anybody. And so prices will be competed down naturally.
I'm going to thank you because he helped me understand how we solved for it. I think we boiled it down to the realization that policies and market incentives affect design choices. And we've all experienced the My One app and the transition from one app to the other and all these things. And we've gone somewhere else and we're like, oh man, I wish my app was as good as this one. And at the end of the day, when we're talking about deepening, because in 2036, we've deepened access to services that people want and use, and through that deepening, we're more productive, we're more stable, we're more resilient. So that deepening meant people were using these services because they're affordable and because they were fairly easy to use. And I think when we thought about the initial policy decisions in 2016, 2010, policymakers and business executives were not thinking about the UI. They weren't thinking about the UX. They weren't thinking about that consumer experience. The demand was inelastic. But now that we're hitting this plateau, we have to be conscious that our decisions will affect how we design these apps, how we make it easier. And we also, and I think importantly, we found the balance because we realized that regulators should not be designing apps. Right? But we also shouldn't accept excuses from the private sector when they say it's too hard to design an app.
Now, and by the way, I want to make sure that if anyone on the floor wants to contribute, please wave your hand. I believe there are microphones that can be made available to you as we go. So please do stick up your hand and attract my attention if anyone wants to contribute. I want to just see, I imagine interoperability was not the only kind of market regulatory area that transformed everything. What about open finance, open banking? Were there initiatives there that made a difference? Did they work? Were they good ideas? Were they a waste of time? by 2036? What's your sense of those? And by the way, if Boniface or Doreen, if you want to come in on these topics, please also do. I'm looking at the two gentlemen in the middle who've got this more sort of market focus in a sense, but open finance, open data, open banking. What's worked in there and what hasn't worked?
I think that's where the leapfrog happened, was on open finance, not just open banking. In 2024, there was a conversation that started in the AU about an African Payment Services Directive along the lines of the EU version. And then in 2026, the AU started a commission hosted by the African Association of Central Banks to start considering the drafting of the PSD for Africa. And what we realized in 2027 is that the only region that could really take that forward was probably EAC, just by nature of the dynamics and the infrastructure and the leadership that was here. And so by 2028, as these drafts were coming out, we realized that Europe had the luxury of starting with PSD1, and then 2, and then 3. PSD1 was payments now would be regulated in a specific way. PSD2 was e-money issuers, remittance providers are now regulated. PSD3 was open banking. PSD4, which is on the horizon, is open finance. We realized in 2028 that the EAC, with Kenya and Rwandan leadership and Ethiopia growing, couldn't afford to start with PSD1. We leapfrogged. We started with PSD4, which means we integrated AI, which means we thought about open finance as a function of depth. It took us 6 or 7 years to find a framework that worked. But by starting with openness as our mechanism, we were able to create this integration, because open finance created this breadth to say customers should be able to move freely between services, between providers. They should be able to take their data with them. They should be able to get an insurance offer over here and use their bank account over there to pay for it and do their daily transactions over mobile money. And that should create a data profile that they can trend into a mortgage, that they can trend into health insurance, that they can trend into other things. It took many years for the regulatory framework to translate into practice. But that vision of openness for open finance, I think, is where the second leapfrog happened.
Okay, well, data is clearly a key part of open anything. And you're talking also about portability there of data, portability of accounts. And Doreen, I think coming from the Office of the Data Protection Commissioner, your statutory priority is not the competitive effectiveness of the market. Your statutory priority is the protection of individuals' privacy, the protection of data. Can you just talk us through a little bit how you look at the issues that come up in data protection when we start talking about these wonderful, exciting ideas of open finance, open data, and so on?
Thank you. We do have an appreciation that the owner of the data controls the market. But what we've not seen is that an appreciation of controlling the market does not mean ownership of the personal data. The ownership of that personal data remains with the data subject. And so data portability as is allowing the subject to be able to move with the data, which in 2026, we've not been able to really make practical. But the implications of that is that the smaller entrants into the market, not the big money, the big mobile networks, are not able to get good quality data. And as a result, flaunting a lot of data protection principles such as data minimization, purpose limitation, because at the end of the day, for them to be able to give a lender a loan, they need to assess your credit worthiness. But they're not able to access the same level of data that the big mobile networks are able to access. Therefore, they want to get into your contacts, they want to get into your emails, they want to get into anywhere that they can get into in order to assess that credit worthiness. And at the end of the day, if you default, they want to, again, harass you using the contacts that they have gotten. So that data quality, ensuring data quality is critical in the protection of personal data. And that means that there needs to be an open data, financial data platform that has assured what quality is. It is critical for data protection that there be open finance, I believe.
So hold on to the microphone, because what you're saying there is very interesting. You're not just there saying minimize and protect the privacy of you're talking about the individual having power over their data, and that with that comes this portability, so that actually the misbehavior, the misuse of data, the going and scraping and searching and intruding into all sorts of communications and your transaction history is going beyond what they should. That misbehavior is happening because you don't have a well-governed data portability system. If you had that, you're saying, actually the whole thing would be a lot cleaner. There'd be better compliance on your end. So there's a direct connection here between your data protection priority and this market solution of data portability. Am I getting you right?
Yes.
Yeah.
That's a position, because if you think about it, those with data do not need to flaunt data protection policies because they have the data. Those without will have to get creative to access data. But if we allow data portability across, then that means that everybody is on the same playing field when it comes to those protections.
Mm-hmm. Boniface, do you want to come in on any of this points? And then Ryan, I'll come back to you.
Yeah, yes, just to add on to the issues of open finance and data portability, because if you look at it from the consumer protection perspective, is that interestingly, whilst we know the aim of competition is to enhance consumer welfare, we also know that once you give the rights of the consumers, the access, and you give them the necessary tools, then that will definitely enhance competition. If you bring in we talk about open finance, and you've given the tools to, consumers to, to access various platforms, as we are seeing now, then it forces the players to compete. They're forced to innovate and come up with new products, new products to capture the market. And also in terms of data, then it means because the consumer owns the data, then it forces the businesses to rethink not just about consumer welfare, but also competition. So that would be my point.
Thanks. Ryan, I want to just probe a little further the open banking, open finance. The data portability is one aspect of it. That's good. That requires the initiative of the consumer to request the data to be ported. Talk us through a little bit that scenario, or the use of APIs by those who are holding the data, allowing access to the data. Data in this business is in many ways the core thing you build in this sector. If you have data on the customers, then you know better than anyone else what risk you can take in extending credit to them or other services that you're going to extend to them. And accumulating that data is the result of investment, of building client relationships, distribution systems, and so on and so on. And so, of course, if you're simply told, well, you have to open your data to everybody else, then in some ways you're being told you just have to give up your entire business model. Talk us through, Ryan, a little bit about how these economic policies work, how that relates perhaps to portability, and where in 2036 can we look back and say they got it right? What was the best emphasis to open up the financial services market?
This is a difficult question, and my colleague Shaista is actually better positioned to speak to this. But if I can speak on her behalf, I hope you won't blame her if any mistakes are on my own on this front. But I think the main issue is that at the moment, I mean, what I thought thought was quite a nice analysis was from Vela earlier. She was explaining how, you know, what happens if there's a monopoly owner of data is that it's not just, you know, it's bad for competition, you know, no one else can get access to the data, etc. It's that there's an exploitative approach, outcome as well. And that exploitative outcome is that, you know, prices are a lot higher. So as I understand it in Kenya, for instance, and please forgive me if this is, you know, this is early stages. You may know this better than I do. But the way that data sharing works from our incumbent monopolist in Kenya is that that's provided, but it's provided on a sort of 30% odd revenue share basis. So you borrow 1,000 shillings, Safaricom or M-Pesa charges the fintech that's doing the clever business to get the loan into your hands 30% of that. So so immediately you've got this enormous cost of lending. Now, so on the one hand, you've got this quite big sort of exploitative, what we would normally call excessive pricing problem. Which is always difficult to deal with. You know, should you regulate? What would you regulate the interest rate, data sharing rate at? I don't know. It's always a bit difficult. But on the other hand, what I also would like to say is that what's happened in a lot of countries where they've introduced a lot of data sharing is actually the incumbents realize it's always forced. Okay, so it's the central bank saying thou shalt share thy data. It doesn't just happen by miracle. But the way that, or you know, if it does happen, it's at these enormous revenue sharing kind of situations. But what does actually happen is what the incumbents start to realize is that they benefit from this. So think about the process of what actually happens in a competitive loan market. You go to a fintech and you say, fintech, I'd like a quote for a loan, please. The fintech then goes and in an open data environment and calls on the API from the incumbent and says, I'd like this customer's bank balance, transaction history, what have you, whatever the information is that they need. And what does that tell the incumbent immediately? This customer's looking for a loan, right? Why, you know, clearly, I mean, this API call hasn't happened by miracle. So the incumbent then has an opportunity immediately to go to the consumer and say, hey, no problem, we'll share the data, we have to anyway. By the way, we've checked your credit record and we can offer you 10,000 shillings at a decent interest rate. And so it's not as kind of one way. It's not this like giant sucking sound from the incumbent to the smaller fintechs that I think the incumbents sometimes picture, or that we sometimes picture, and we think, gosh, that's unfair. Think of all the infrastructure. Think of all the undermining of the investment incentives and so on, which are important to think about. But it isn't this giant sucking sound that actually happens in practice. Yeah. So I think it's less harmful and less investment reducing than is sometimes made out. But I also think it's extremely exploitative if you do absolutely nothing. So I would say those two things.
And in other markets, the UK being one example, just give us a very quick sense of the impact of some of these policies in terms of increasing innovation and competition.
That's a great example. So there's a very nice paper on SME lending that went up significantly. So lending to SMEs in the UK went up, and that's a very nice high quality economics paper. But second of all, I would actually say there's a lot of very good research on Brazil. And what Scheister's research is currently suggesting is that what actually happens is that the fintechs, in Brazil, so we've been talking a lot about open data and interoperability, but there's actually a third thing as well, and that's proportionate licensing. So the Brazilians went aggressive, and they said, look, anybody, frankly, with less than 500,000 customers, I think it was, you don't need a license to set up to be an e-money issuer. You just, let us know, notify us, but you go ahead. That's changed now a bit, and they've closed. But they're a very open, fragmented market in which basically anybody could come and set up a fintech lending operation. What happened was, and you can see it in the data in Brazil, is that the proportion of higher risk loans that are going out into the markets are substantially higher now. So loans are being made now to more and more risky customers, to more and more marginal customers as competition intensifies. And as competition practitioners, of course, we think this is a good thing, right? You want people who were previously unserved completely, or who are frankly served informally at, in far worse circumstances, to be served by the formal financial system. And that's what these small arrivals actually end up doing, is pushing the frontiers of the market way out. And my point about all of this is that this does not cannibalize the incumbents, to the extent that you kind of think that there's this giant sucking sound as soon as you have open data. Anyway, okay.
Right, so there's a way to bring the market incumbents along with this sort of policy change. I want to continue in the focus on data and how it's used in just a moment, but I want to pause a little bit on the digital credit side, because you were referring there to the costs on lending, which come out of the large revenue share that M-Pesa is able to charge in digital credit. Do you or does anyone else on the panel have a sense of how much that is what drives the high price of digital credit in Kenya, which is quite high, even though there's a huge number of providers in the market? I mean, it's a remarkable sign. If you have a lot of players in the market, but the price is high, then there's some problem in the market happening. That would be one theory. Another, which is I think often referred to by digital credit providers, whose prices do get approved, many of you be aware, by the central bank. They argue, well, we need these prices because we're carrying high risk of default, because there are high default rates in the Kenyan consumer market. And why are there high default rates? Well, because we're not able to assess their credibility, the credit worthiness well enough, because we don't have the data. So it comes back around to your data access kind of issue. Where would you put the accent here, or which of these two is bigger? The M-Pesa kind of revenue share piece of digital credit, or access to data for digital credit service providers? If anyone does know this, we really want to know this. I think we're about to start doing some work on a digital credit inquiry, so the answer would be wonderful. Go ahead, Manfred.
No. I wouldn't know what's really, although that's what they say, that because of the high risk, the high issues of default, and but the regulations, I would say they've not really matured to the point of really being able to rein in on these providers in a big way. So I think there's some sort of progress still happening.
You're talking about the 2022 digital credit regulations that came in?
Yes.
Yeah. Tell us a bit more about those. Yeah.
Yeah. So initially, as I mentioned, the Wild West, where most of the providers were in, and the issues associated with borrowing at that time, there's still some issues. And then there's the digital credit providers regulations of 2022 that came into play, and we saw some default rates going down, mainly because before that there was weak regulation. But with the regulations that came into play, then we found quite a number of providers came under the purview of the Central Bank of Kenya. And that has really assisted a lot. Secondly, the regulatory fragmentation in the sense that there was the competition authority handling certain issues, central bank, the other financial sector regulators handling issues on their own. But now all the regulators have come together and there's a draft financial consumer protection framework. And that has also reduced, forum shopping, amongst the providers, we are seeing the number of complaints having reduced. So there's some improvement. We are not there yet. We are not there yet. There's still a lot of work to be done. I know from the data from the ODPC, there are a lot of issues on, still issues, not just on conduct, but also on aggressive debt collection practices. So there's still some work to be done, but we can see some progress. Yeah.
So but hold on to the microphone, Boniface, just a moment, because those regulations came in. They required digital credit providers to register to get licenses from the central bank, and then their prices are regulated. They're followed by the bank, by the central bank. You said that those are maturing. There's better cooperation, and I want to come back to that a little later amongst the authorities. At the CAK, as a consumer protection body, you receive complaints, and I imagine you get some of the fallout of cases where compliance is still not quite in order, and consumers come to you. Perhaps they didn't get the answers they were hoping for from the central bank. Can you just give us a sense of the types of cases you see coming to you in the digital credit space?
One, I would say, very, very big advantage with our law, which Parliament, when the Competition Act was coming into play, is that we are able to take tough decisions. Our board of directors is really equipped to make decisions. We have a great team of investigators, and our law is also broad enough to look at a myriad of consumer issues, not just in the financial services sector. And I think 10 years ago that you mentioned, that's when we were able to really push telecom companies and other institutions to implement disclosure and transparency requirements. And also the imposition of various penalties on these financial sector providers, digital financial providers, by the CAK, by the Competition Authority of Kenya, has brought in some sort of sanity.
What were you seeing? What were the problem behaviors that you've managed to improve through enforcement?
So the problem behaviors, as indicated, there was a lack of disclosure of fees and charges. There were unconscionable terms and unconscionable terms and conditions. There were terms and conditions that were not being disclosed at all. I remember there was a player that we penalized in the financial services sector, and basically they had contracts for provision of financial services, and they were charging fees in US dollars at that time. So you can imagine the costs to consumers. So we came in and intervened. So those are just some of the things that we saw, and if it wasn't for the intervention of the authority, then I think it would have been quite worse off in the financial services in the market. But now the regulators have come in to really bring some sort of sanity, not just in the financial services in relation to loans, but also in relation to the insurance sector, the capital markets, the retirement benefits sector, etc. So there's a financial consumer protection framework. Right now it's in draft form. All the regulators and also ODPC is in it discussing that. So once it comes into play, then what we know that it's going to be good for consumers. Yeah.
Where will consumers go then for their main digital credit complaints?
Well, right now what is happening is that because there's the DCP regulations in play, so the Competition Authority of Kenya, when it receives complaints which are related to conduct issue, issues, then we refer them to the Central Bank of Kenya. If we receive complaints relating to data issues, then we take them to the ODPC. We are able to receive quite a number of complaints, and once we forward them to the relevant regulators, then they receive the attention they deserve. We have seen ODPC really taking action on some of those providers, and also Central Bank intervening in various aspects. So as CAK, we feel our work is the sort of that sanity that is coming into play just because of the collaboration and the cooperation with all the government agencies.
Well, this sounds like we're already on the way to our 2036 goal. Doreen, let me ask you, because Boniface was referring to how the CAK will refer over to the ODPC cases. Tell us a bit about what you're seeing in terms of behavior using personal data, where you at the ODPC are intervening, carrying out investigations, making determinations. What sort of cases? Which ones are coming from CAK? Which ones are coming directly? I'm mainly focused on digital credit, but more broadly on digital financial services, as you like, please.
So since inception of the office, the digital credit providers have been the most notorious respondents. Over 50% of complaints since inception, and we are now at 10,000 something complaints. Over 50% are from the digital credit providers. If you add the financial institutions, we are at 60%. So those are the biggest respondents when it comes to complaints of misuse of personal data. Prior to the office coming in, we had very aggressive debt collection practices. I don't know if you've heard about them. People used to be put in WhatsApp groups, your entire family, and told, this guy owes money, or your boss is called. But we have seen a sharp decline with the office, I believe, in 2024, issued a guidance on how personal data is to be handled in as far as digital credit providers. There's also been trainings with the financial association, the financial services associations. So we have seen trainings and this guidance, and this collaboration, even with the office, create a sharp decline. However, we are still receiving a bit of those complaints when it comes to the misuse of personal data. In fact, the more traditional financial institutions are getting worse, and the digital credit providers are getting better.
Is that because the big ones have an inertia? It takes them too long to turn a huge ship? Is it that, or what is it?
I think there's that. Also, the lack of accuracy. I think once they acquired consent, or at the beginning, not many care to update that consent. So we're seeing it's things that are just, you just are not following up with accuracy. And so I think, I don't know if there's a need for refreshing on what requirements are in as far as data protection in financial services. So the fines that have been issued, every time we issue a fine, guys get in line for some reason. When a fine is issued, everyone remembers that they need to either re-register, do a DPI, so I think fines have become the most interesting tool of compliance, and it will be interesting to see what this looks like in 2036, because we've heard that there are certain credit providers who make so much money that they will budget for the fine, because our fines are relatively low. They're capped at 5 million. So that seems like a risk costs, but for most of them, it's a reputational issue. So they're more concerned with the reputation than they are concerned with the fine. And so you'll find that even some of the complaints, especially against the big financial service providers, will go to mediation because they would hate for it to get to a conclusion and determination and a fine, and for it to be out there.
So, and hold on to the microphone because I want to probe this a little further. So it's really exciting to hear how fines have this impact. They wake you up. Underneath that, you were saying that essentially there's a need for, particularly the larger institutions, to improve their overall data governance practices, how they organize the data, refresh consents, make sure that they're really always focused on that. That leads back into good data governance back into some of the data portability or the open data, open finance themes. What would the role of the ODPC be in helping the economic policymakers, like the central bank, as they may move forward in these sort of more market opening initiatives, but they're so data-centric? What would your role be at the ODPC there be to help make sure the data governance practices are strong?
So to start, the office has come up with a data sharing code. It is, I think, a lot of the private sector thinks that the office is there to stop you from sharing the data. It just needs to be lawful. And so there is nothing in the Act that says do not share this data, do not use the data. So the office has come up with a data sharing code that essentially guides on how to legitimately share data between private institutions, between public institutions. In addition, there is collaboration with the CBK, where now for you to be able to register as a financial services provider, you need to be registered with the ODPC. And so that collaboration has also led to trainings, to giving advisory to the sector when they want to come up with systems or frameworks. The office has the advisory function where now you can write to the office and actually get advice on how to move forward with the system. And also in as far as doing the DPIAs and having the Office of the Data Protection Commissioner review the DPIAs, then you're able to know that either your system has enough safeguards, does not have enough safeguards, is it satisfactory to your regulator? And so even before the point of implementation of these systems, your regulator is aware of what you want to implement, how you want to implement, and how you conduct, and how you've put in place your safeguards.
And so looking back from 2036 again, and we managed to introduce healthy open data, open finance solutions with good data governance. Looking back from 2036, could you give a sense of how well did the central bank cooperate with the ODPC, with the CAK? Perhaps, Boniface, you can come back in on that, because you mentioned earlier this regulatory fragmentation and then cooperation. But Dorian, since you've got the microphone, how did that collaboration work amongst those regulators to get to 2036?
I think there was a framework for the regulators to work, and this framework was also involved the sector. So together they came up with a way to work together, know their requirements. Actually, I think many EU countries, especially, I've seen the guidance not come from the sector. The guidance always comes from the sector, and then the regulators adopt or ask for certain changes to be made. I think that is a good route to take, because the sector understands their needs, they understand their customers. Then once it gets to the regulators together understand how do we need to protect our citizens within our mandate. So that collaboration between sector and the regulators collaboratively is how we got to 2036.
Okay. Boniface, can you come in, and then Ahmed, you might have some thoughts on the collaboration amongst authorities.
Yeah, like what Doreen said, the penalties is a big thing. It really drives compliance, and that also pushes sector players like the association, the Digital Financial Lenders Associations, to engage government. And they really want to engage government. They have been very, very proactive, saying, come in and tell us what we need to do. Those who are out there in the Wild West are seeing that, no, we cannot operate in the Wild West. We need to come and join the association and engage government. So they're more willing now to really follow the rules and come up with innovative ways of enhancing the welfare of consumers. Yeah. And the collaboration, the other sector regulators has really helped, because you see, when one regulator comes in to penalize a certain party in a certain sector, then the others see that, oh, there's a problem. There's a problem somewhere. Can we come together and just resolve this whole issue? Yeah, so the prospects are good.
Ahmed.
Oh my God, so many thoughts. I think it's fascinating that 60% of the complaints are from the financial services sector, and then 50%, not of the 60, 50% of the total are digital credit. So there's a couple things. We have a saying on my team that the best regulation is the next regulation, that the purpose of policymakers and regulators is just constantly keeping up. But you've also inspired me now to have another saying, which is you're only as good as your last enforcement action, right? Those two things, because if you're always drafting new regulations to keep up, well, then, you know, where's the muscle behind the movement, as it were? And I think getting that right, you know, we're talking about the intersection between consumer welfare and competition. And there's clearly, you know, a very complex balance there, because, you know, earlier when you brought up the digital credit thing, we've been talking for 40 years on the high cost of microfinance. And at the heart of that, it's that it's too risky. Our PAR is X, our NPL is Y, and therefore, and regulators have come in and said, no, the interest rate needs to be capped. And then that's been catastrophic, which means people don't have productive credit. So then if we assume that trajectory to be right, and then we find ourselves in this position with digital credit providers, and this observation that we're seeing a ton of competition, but high prices and abusive practice, so something is wrong. I think it's really fascinating how that can be a lens for how we solve for those kind of circumstances, not just digital credit. And it strikes me, and I'm curious if colleagues agree, that, you know, we need to figure out now what the new levers are for policymakers. And you mentioned associations, because I think we're starting to see the benefit that associations see in reining in their wild actors, because it's sort of ruining it for everyone. And a couple things that I'm hearing that we certainly see in different markets, but at different degrees, is the importance of not just coordinated action, but the ability to respond quickly. So Rory and I over lunch were talking a little bit about, like, what does that coordination system look like? Honestly, it doesn't matter as long as you do it all the time and that you can demonstrate you can do it quickly. I was in Uganda a couple of weeks ago, well, 4 weeks ago, and we were talking to some regulators, and their concerns were these loans were going out for 48 or 72 hours, and they were being abusively collected over the following week, and they don't get those complaints for 2 months. And then those aggregate. So they don't have the capacity to respond quickly. And the institutions that some of those funds pass through are in a different regulator. So how do you deal with the digital component, which facilitates and encourages this rapidity, and customers where there's infinite demand, right? Just wait for the World Cup, right? The digital credit numbers are going to skyrocket. You know? And so we now have to respond in a coordinated fashion. But it strikes me as, you know, and this is the question, is how do we solve for? So I'm hoping in 2036, we solved for this balance where we protected data as sort of associations and government, where we agreed on these standards, but we also made data publicly available. Because I think the question we also have to ask is these providers who say, oh, the customer's too risky, they don't know how to manage risk, or do they know exactly what they're doing? And the plan is, how long can I get away with it? I can make a whole bunch of money doing this really quick. And if I can survive 2-3 years without an enforcement action, and I just make a bunch of cash, and then I put it into an apartment or a building or whatever, and I move on to my next business. So they have no interest in responsible, which is why this fascinating observation that the incumbents are doing worse. So, like, is this now the maturation of an industry on the horizon, but we still have to deal, and maybe this is my last point, One thing we saw in Uganda is that women in particular geographic areas, not always rural, but in some urban settings, were so burnt by the abusive practice that they're opting out of the system entirely. Right? That's not an example of inelastic demand. That's informal systems suit me better, which means the implication of not managing competition in a consumer welfare context is that we plateau again. And it's going to be harder to get those customers back into the system because we've lost their trust. So the real implications of getting that wrong, when abusive actors have no interest in being responsible, and that goes back to what's your last enforcement action. So that was not organized at all. That is just me reflecting on some very lived experience. But it does sound like we're getting closer. My big question is whether we can act as agilely as we need to. And maybe to your point, Rory, in 2036, we figured out how to respond agilely, because in 2036, because in 2026, we were not.
So going from cooperation amongst the regulators to regional cooperation amongst countries, by 2036, we've got a reasonably good interoperability of payments and transfers occurring, and it's allowing all sorts of things to innovate in an increasingly integrated market. Ryan, maybe you could just give us a sense of where were we back in 2026 in terms of the integrated market and digital financial services in the East Africa region, and then how did we get to a really happy place by 2036?
As I understand it, and the people in this room will know this better than I, but actually I think the East African countries have quite an advanced approach to regional remittances. And in fact, I believe, and one of the things that I think I'm very personally excited about is reciprocal recognition of licensing. So to the extent that central banks in the region can recognize each other's skills at checking whether the directors of a bank or a remittances provider are, fit and proper and so on. I think that's incredible, and I think that might create a very, very vibrant remittances markets or cross-border markets in the coming years.
Where services are crossing borders, payments are crossing borders, data's got to cross borders. Just to give us a sense of what has to happen from your perspective at the ODPC for that to happen well.
So from 2036, Kenya has had adequacy from different regions, has given adequacy to different regions, and there are enough safeguards to be able to have free flow of data.
Adequacy meaning, just explain a little more.
Adequacy means that adequacy from Kenya would mean that we recognize another region to have equivalent protections of personal data as those that we have at home. So currently Kenya is in adequacy dialogue with the EU, where EU would recognize Kenya as a safe destination for personal data. And what that would mean is that data from the EU would be able to flow to Kenya and vice versa without having to do the additional protections. That's I'm sure you're doing data sharing agreements which are bulky, you're doing binding corporate rules which are bulky. So if regions give each other adequacy, it would mean that businesses do not have the additional need to create safeguards within themselves for that free flow of data. So we are hoping Kenya will be the first African country to get an adequacy decision from the EU.
Go for it. Go for it.
We're in advanced stages, so hopefully.
and then you'll start negotiating adequacy agreements with your surrounding neighbors.
So we're trying to work on it with the EAC to come up with an agreement of sharing. It's strange that it is more difficult with your neighbors than it is. For some reason, maybe someone from EAC can share on this.
Well, so just to close off, because we're out of time, we're here in 2036. We solved so many things. We solved the open finance, open banking, we got interoperability working. We got data flowing smoothly. but what did we not manage to solve by now that are really long-term persisting problems that give us headaches? Who from the panel would just like to offer one problem just seems really hard that we haven't figured out how to crack? Boniface.
What we haven't been able to resolve is cross-border consumer protection. Yes, there's an increase in fraud happening across. We receive complaints on fraud issues, and I'm sure it's the same in other countries. So we've not been able to solve that. So that's the pain.
And why not? What made it difficult?
Well, there is it's the coordination. We are attempting to and doing well in coordinating nationally, but regionally and internationally, we are not doing that. We are not protecting our consumers across the borders. And for example, we receive complaints of consumers from other countries who've been defrauded. And also there are Kenyans who are defrauded out there. So we are not able to protect those consumers. That's what we haven't been able to solve.
Okay, well, good luck working on it. Pass the microphone down. Let's see if anyone else has any thoughts on unsolvable problems.
I think in 2036, the giants will even be bigger because they're faster in adopting technology and they have bigger resources. And so enforcement will even be harder. So if anyone can come up with an enforcement measure against them that works, this would be the time to avoid it being an issue in 2036.
Enforcement. This is coming back again and again. Ahmed, last word?
Execution of the enforcement, because you can give the decision, but how do you make sure that that decision is actually complied with?
This is a hard one. It's a really tough question. Maybe it's just because I have so much faith that there'll be problems we can't even imagine. So it's hard to imagine, because I feel like the problems we have now seem doable, particularly over the course of a decade. But I'm going to be the guy that says the AI thing, because you can't have a panel these days without it. But I think it's going to come in the context of frauds. And I think it's going to come in the context of regulators are always behind. And I think the nature of the consumer relationship generationally is going to be the issue. I think we're going to see older generations of customers having an experience that is going to be virtually impossible to manage from a regulatory perspective, to discern reality from otherwise. And I think regulators, the soup tech systems that we're envisioning now, don't really yet account for the infrastructure that central banks, ministries of finance, data protection authorities, competition authorities need to have in-house. I don't want to get Minority Report on this, but there may be a point where we're going to have to predict where the risks are coming because we have so much data incoming. But I don't think we're going to be able to do that. And this hesitancy to lean into that means that we're just going to be inundated with AI-related, agent-related risks that consumers are just being defrauded en masse, and it's almost going to be impossible to enforce because we may not also be able to discern reality. By the time you do, it might be too late. So I just don't see how governments are going to keep up with the AI context in the way that we're always, the next regulation is the best one. We're always one step behind, and I'm worried. I'm really worried about that.
So we've covered competitiveness of the market, problems of competition, lack of competition, barriers, bottlenecks in the market, high costs of digital credit. We've looked at the data elements of that and how that feeds into a healthier digital credit market in particular, could bring down costs. We've looked at, Ryan's talked particularly about the high revenue share part that M-Pesa takes out of quite a number of services in the market. We've talked about data protection, privacy, consumer protection. We have solved all the problems by 2036, but there is still the AI one, which I think you're absolutely right is going to be bigger. So anyone who's worried about AI taking your job as a regulator. I think the opposite may be true. Actually, there's going to be all the more work for all of us to figure out the solutions. But in walking us through all of these issues and trying to link them up together and see how they interrelate, I'd like everyone please to give a round of applause to our panel, who I think has given us a very rich insight. Thank you.
Thank you very much, Rory, for taking us through the session. It was a very interesting one, which I enjoyed. We'd just like to have you stand up for a quick photo. As they exit the stage. I'd like us to take just a minute or two to get feedback from you. For those who have name tags, behind the name tags, there's a QR code. We kindly request you to just scan it and give us feedback in the evaluation form. If you don't have the name tag, on the table, there should be a printout which has a QR code. So you could just take 2 minutes to kindly scan it and fill the evaluation form for us. Just 2 minutes. If you're not able to access the QR code, you can raise your hand, then someone will come and assist you. So as we fill the evaluation form, I'd just like to thank you for giving us your time from morning up to now. We've indeed have had very deep and informative conversations from morning during the plenary sessions, all through the breakout sessions and even this afternoon session. And I'd like to specifically appreciate the presenters, discussants, and the panelists for just willingly and freely sharing their deep information, knowledge, and insight with us. I'd also like to thank all of us as participants for just paying attention, and for sure you've been a very good audience, a good one, and I believe that by the time that you get home today, you'll have a lot to reflect on, you'll have a lot to think about. And just 1 or 2 announcements. Before you leave, we have a cup of tea for you at the same place where we took lunch, Lelai Restaurant. And as you take your cup of tea, immediately after, we'll be proceeding for a cocktail session. So it's served right opposite the area where we'll be having a cup of tea. So allow me to invite you for a cup of tea, and then we'll have a cocktail session. From the time you're done with tea, there's a team that is going to be taking you through that. And tomorrow, we are going to start our session at 9 a.m. So I'd like to wish you a safe journey home on behalf of the organizers, also to just say thank you. And we are hoping to see you tomorrow. We still have a lot of information and knowledge to share with you tomorrow. So we believe we'll be together at 9 a.m. tomorrow. So thank you, Sana, and asanteni sana. We can appreciate ourselves for being a very good team. We can give ourselves a clap. Thank you so much, and enjoy your evening. We can proceed to the cocktail and tea area. After you fill the evaluation form, please. Thank you.